Mic, mic check. Mic, mic check.
Good morning and welcome back to docket number 250403. We're here today for the late filed exhibits hearing in this matter. We have an agenda in front of us today. Before we begin, I will pause for any public comment and then we will take up administrative matters. Is there anyone here wishing to provide public comment in this matter? If not, let's move to administrative matters. I'll check first with the applicants.
Thank you. Just one administrative matter. On August 6th, we had submitted a letter to Pura in response to the request about witness panels. And in that letter, we identified that Lucy Texera is out of the country with a family commitment. So she's not available today, but we have, in Ms. Texera's place, we have Deborah Zabo, who's the Director of Rates and Regulation for Aquarion, and she's prepared to testify in place of Ms. Texera.
Very good. Thank you. Are there any other parties or interveners with administrative matters? Attorney Miranda.
Good morning, Joey Lee Miranda from Robinson and Cole on behalf of the National Association of Water Companies. I was going to ask the applicants questions about material that they filed confidentially, which under a motion for protective order, and in particular to elicit whether all of that material actually should be under protective order, that redacted documents were not put in. But I noticed just a few moments ago that the authority granted the motion for protective order with respect to late file exhibits 59 and 61. And I was wondering how I can still ask the questions here, and at the time I'm finished with my questions, if it comes to light that that material is public, perhaps at that point I can raise an issue for reconsideration. Is that the best way to move that forward?
Yes. So let me just say this back to you because I think that that's the correct path forward. At the conclusion of your cross, you're going to ask to move into confidential session and no.
No, I apologize. So I don't have access to the confidential material. And so what I want to learn from the panel is if some of that material is actually available publicly. For instance, real property held by the company would be in the land records, and so therefore public. And so I'm struggling with why the entirety of the exhibit was put in under protective order versus redacted. And that's the piece I'm struggling with, is that this morning the authority granted their motion for protective order, and we haven't had time to elicit from them whether or not that material is actually public. And so my question really is, at the end of my cross, would that be the best time to request that the authority reconsider the ruling on the motion for protective order, or do you want me to try to handle that now? Just trying to understand what the best way forward is.
Thank you for clarifying. I think the best path forward would be to everyone's now on notice that we're going to that we're likely going to take up a motion for reconsideration. So we can do that at the conclusion of your cross after you've had a chance to ask those questions. So we'll take it up then, and then we'll ask the companies to be prepared to respond.
Okay, thank you very much.
Thank you. Any additional parties or interveners? Okay, I think the authority has one. I could have overlooked this, but has the company produced the response to late file exhibit 31?
I believe we have. It's not on the website.
I'm sorry, Attorney Canavan. You said you don't believe or you do believe?
I do believe we have. Yes.
Okay.
Are you not seeing it?
I am not in receipt of it, but it could be a user error.
Okay, let me run that down for us.
And yeah, and we'll definitely look into that. I believe that one has a voluminous number of attachments, like somewhere in the range of like 30 or so attachments. So I wonder if that's why, in terms of maybe the method of filing in bulk. But we'll definitely check on that and make sure that you can get a copy.
Okay. Was it filed confidentially or is it just a large number of attachments?
I believe it was just a large number of attachments. I don't believe it was confidential.
Okay, thank you. Yeah, I'm could still be user error, but I'm not seeing it on the external website right now. So if we can look into that, I'll check with you on a break.
I could add, I know that through the service list, there was an email sent with a link to a SharePoint file to download the files because of the size of them. So that could be part of the confusion.
Okay, thank you. Yep. We only see things that are filed into Lotus. So hopefully we can run that down together. Okay, anything further before we begin? Seeing anything? So I'll turn to the applicants. If you can have your panel adopt late file materials, and then we can move into cross, please. Are there any new witnesses to swear, or was Ms. Sabo sworn last time?
Ms. Sabo has not been sworn, so she would need to be sworn in, please.
Okay, let's start with that, please. If you could state your name for the record, please.
Deborah Zabo.
Very good. I'm going to administer the oath. I swear to tell the truth, the whole truth, and nothing but the truth under pains and penalties of perjury.
I do.
Thank you. Attorney Hum?
Thank you. Good morning, Ms. Sabo. Can you please just, again, for the record, state your full name and position?
Sure. Deborah Zabo, I'm the Director of Rates and Regulation for Aquarion Water Company.
And have you previously testified before PURA?
I have.
Did you participate in the preparation of responses to late filed exhibits sponsored by Lucy Texera that are filed in this proceeding on August 4th, 2025?
Yes, I have.
And are you prepared to testify on the contents of Ms. Texera's responses to those late file exhibits?
Yes,
Do you have any changes to Ms. Texera's responses to those late file exhibits?
I do not.
And is the information provided in Ms. Texera's responses to those late file exhibits true and accurate to the best of your knowledge and belief?
Yes,
And do you adopt the responses to the late file exhibits sponsored by Ms. Texera under oath today?
I do.
Thank you. And Chair, would you like me to continue with the rest of the witnesses to adopt their late file exhibits?
Please.
Thank you. So next, good morning, Mr. Lawrence.
Good morning.
Mr. Lawrence, did you sponsor responses to late file exhibits in this proceeding on August 4th, 2025?
Yes, I did.
And were those responses to the late file exhibits prepared by you or under your direction and control?
Yes.
And do you have any changes to your responses to those late file exhibits?
No, I do not.
And is the information provided in your responses to those late file exhibits true and accurate to the best of your knowledge and belief?
Yes.
And do you adopt your responses to those late file exhibits under oath today?
Yes, I do.
Thank you. Now, Mr. Norman, good morning. Did you also sponsor responses to late file exhibits in this proceeding that were filed on August 4th, 2025?
Yes.
And were those responses to the late file exhibits prepared by you or under your direction and control?
Yes.
Do you have any changes to your responses to those late file exhibits?
No.
And is the information provided in your responses to those late file exhibits true and accurate to the best of your knowledge and belief?
Yes.
And do you adopt your responses to those late file exhibits under oath today?
Yes.
Thank you.
Good morning. Now moving on to the argument witnesses. Ms. Kowalski, did you prepare or assist in preparation of any late file exhibits filed in this matter?
Yes,
And do you have any modifications to those responses at the
No.
time?
no,
Adopt them as your testimony.
yes,
Thank you. Mr. Lakshmanarian, did you prepare or assist in the preparation of any late file exhibits filed in this matter?
Yes.
Do you have any corrections or modifications to those responses at this time?
No.
Do you adopt them as your testimony today?
Yes.
Right. Thank you.
Thank
I think with that, the panel is available for cross-examination.
Thank you. And we'll begin cross this morning with the Office of Consumer Counsel, please.
Good morning, Albert Sablowski for OCC. I'd like to first start with late file 2, attachment 1, and specifically tab IOU RRQ AWC-CT. Just let me know when you're there.
can you just repeat the tab that you want to reference?
Yes, it's the IOU RRQ AWC-CT.
Got it.
Got
I'm
it?
there.
Okay, so line 16, cost of service, in parentheses here it states, assuming perfect rate making. What does that mean and what does that stand for?
So how this was prepared by our M&A advisor, it used the timing of the rate applications that were in what I'll call the seller's model. However, to be conservative, we actually capped the current authorized return of the 6.46%. So that was a modification that was made. And other than that, though, the timing was left as it was in the seller's model.
And why would one assume perfect rate making, this model?
I don't think, when you say perfect rate making, it was, again, to be conservative, we left the 646, which was actually lower than what was in the seller's model and the projections. It does utilize the 6.46, though, in the other information that was used for the comparison. What we're really trying to do here is take The AWA model, at the one that was available at the time this was done, that included the acquisition debt and then included, really the lower cost of capital on the ongoing capital requirements. The two scenarios, the IOU and the AWA, they did both have, this was an adjustment that we made so the capital in each would be equal. And we're demonstrating that, a key driver is the lower cost of capital, even with that conservative assumption. We did build in here, or Barclays built in here, the benefit also of the income tax that's also captured and broken out separately. And then although the pilot does go up, it does, as we talked about, go up at a lower rate. So we did believe this was a conservative assumption to use.
Thank you. And is this model assuming rate increases every 2 years?
It's actually based on 6 rate increases during the 10-year period that are ruled, that have been rolled into based on the anticipated effective date. And that was consistent with the seller's model.
And has that happened for Aquarion in the past?
It hasn't happened in the past, and I could defer to Eversource, but I believe the testimony the other day was that it's expected that there'll be more frequent rate applications going forward. I don't know if Jeff wants to add anything further.
That's our assumption.
Okay. But I guess just to follow up on that, so, and to be more specific, has Aquarion received this frequency of increases in a row in its past as this model is forecasting into the future?
It hasn't, but it also hasn't applied this frequently. As I said previously, with the amount of capital spending, there's going to be a need for more frequent rate-based resets in our regulatory process, and will be the strategy going forward if there's not a transaction here.
Okay. And that's sort of excluding WICA, correct?
That's excluding WICA.
Okay. But WICA is accounted here accounted for in row 61. Is that correct?
Yes.
Okay.
WICA is accounted for, but the HB 6777 is not accounted for because it wasn't known at the time.
But okay. And the base revenue in row 60 is increasing annually? Are you seeing the same thing?
Can you ask the question again?
Sure. If we look at row 60, base revenue seems to go up annually. Is that correct?
It is, yes, it is going up annually.
Thank you. Okay. Looking at row 24. This is forecasted annual rate base, correct?
I'm opening row 24.
Yeah, so row 24.
I see row 23 and 25.
So in that same tab, okay, at least in my version.
I see, okay, I see it, yes.
Okay, thank you. So the question was, is this forecasted annual rate base?
It's forecasted annual rate base. However, my understanding again is from the going forward capital, the two models were comparable.
Okay. So for 2025, the rate base is projected to be about 1.479 billion.
Yeah, based on the model, yeah.
Okay. So is this the end of the year rate base or average rate base?
I would have to confirm that if I were, this is just a guess that it would be probably the end of the year rate base, but the rate increases on the rate base were timed. So in certain years, depending on the timing and the seller's model, it might be like 50% impacting that at a particular year, maybe 75% or maybe 100%, again, based on the timing.
Okay, but just to have a sort of an apples to apples comparison here, what is typically used for rate making purposes? End of year or average rate base?
We would use end of year.
Okay. And Aquarion's current rate base as of Q2 2025 filing in docket 860906 ARIA 1. So as of the midpoint of 25 is about 1.26 billion. Is that right?
I don't have that file open, but if that's what it was in the submission, I'll take your word.
Thank you. And looking back at row 24, it looks like this assumes an increase in rate base for 2026 up to about 1.8 billion in this model.
That's correct in the model.
So if the current, so that's about a 22% increase in rate base for a single year, correct?
It is a significant increase, yes.
Okay. So are plant additions driving those assumptions?
That's my understanding of how the model was done, yes.
And are those calculated based on forecasted in-service dates or capital expenditures?
It's my understanding it was driven by capital expenditures primarily.
Okay, so this increase in rate base by 2026, which is about $500 million higher than the last reported actual rate base as of June 2025. This is driven by projects that will enter service over the next year.
It would be calculated based on the traditional IOU rate base calculation.
Okay, so I guess, let me rephrase the question. Is there $500 million worth of rate base that will enter by 2026?
I'm just going to check the AWA model. Just give me a minute on that. So we would have, I'm just looking, we have like 467, at least capital expenditures just by the end of fiscal 28, which would be June of 28. But you could also have other, like CWIP also going into service.
Okay. But that's, so you said 2028?
Our fiscal years, which are different.
And is this rate base inclusive of accumulated depreciation?
It is adjusted. And I'm just going back to that.
where could I see that in this exhibit, if at all?
If you go to, you can see like that there's AFUDC adjustments and other adjustments to the calculation.
And so for 2025, that's 500. Let me see. What is that number for 2025? Sorry, text is small. That's 530,000, is that correct?
I mean, I'm trying to follow where you are.
Yep, so
Yes.
you said
Yeah, great,
FAC,
yeah.
so, okay, 530,000, correct? For 2025?
Correct.
Thank you. What about depreciation expense? Is that accounted for somewhere on the expense side here?
It would be accounted for in the expense side. Again, the intent is to use what I would call traditional, like IOU rate making, you know, per primarily the seller's model, adjusted for the consistent 6.46% as opposed to an increase, and using the same, you know, capital forecast.
Hmm. So would that be in row 38, additional operating expenses? Or somewhere else? Or nowhere in this model?
Yeah, it's not in additional operating expenses. This is just the operating expenses itself, is my understanding.
It's just, I noticed that row 38, additional operating expenses are 86.2 million for 2025. But even under the revenue requirement for 220701, allowed O&M was about 69 million and depreciation expense was 37.6 for a total of 106.6 million, and that's pre-tax. And also before the allowed acquisition adjustment. So how is this model assuming OpEx that is 20 million less than that?
I just want to check more about if the additional operating expense includes depreciation, so just give me a minute. Row 34 is depreciation and amortization.
Okay. And is that 52.45 million?
Correct.
Okay, thank you. Then you mentioned both FUDC and QIP. Do Connecticut utilities typically get both of these?
So my understanding, although I would defer to the Aquarion team, is AFUDC would be, you know, basically a deduction. CWIP probably often no, but it could also depend, at least in my prior experience outside of Connecticut, could depend on when the CWIP was anticipated to go into service.
So just gonna repeat my last question for row 38, because I don't think I got an answer, and that is the additional operating expenses are 86.202 million for 2025. But even under the revenue requirement for 220701, allowed O&M was about 69 million, and depreciation expense was 37.6 million for a total of 106.6 million. That's pre-tax. So how is this model assuming operating expenses that is, I want to say about $20 million less than that?
I'm just looking, I know, I'm going to the AWA page, the model at the time. So the model at the time, again, this is in fiscal years. So it's, June to May. The total operating expenses was, including the pilot as well as operating expenses, by a fiscal 2027, so 6/1/26 to 5/31/27, was forecasted to be about 115. This does incorporate like some due diligence adjustments that we made. So the 106 actually sounds potentially lower than what what was used for the AWA model, if that answers your question.
Okay, I'll take that. Thank you. I have some more questions on this model. Is the equity layer here? Hold on the equity layer here.
That was
This is
consistent with coming out of the 2022 rate case.
okay. It says here that it's 53.1. What's the current approved one for Aquarion?
My understanding is this is it because it comes to the 6.46. That was the intention, to use the current authorized return. And again, thinking that that was conservative, both from the debt as well as the allowed ROE.
Maybe it's a question for Aquarion, but what is the current approved?
So
equity?
the 6.46 is the authorized weighted average cost of capital, but the structure is slightly different than what's shown in that late file two. The authorized equity is 50.35%.
So the assumption of 53.1 here is based on what, like a future possible outcome of pure allowing a 53.1, or is this just an error?
The intent here was to model the overall authorized rate of return, which is the 6.46. I don't believe that because it's still based on the 6.46 that there would be a change in the outcome.
So if the equity layer here is higher, I mean, the debt layer would be lower. So there's still an error somewhere in this calculation, I guess.
But there may be an error in the breakout, but the overall authorized return, as we understand it, is a 6.46. So if equity is high, then, the debt is probably, maybe lower, but it's still based on the 6.46, which we believe was conservative.
So we arrived at the correct WACC. It's just the pieces that go into the calculation that were used were just incorrect.
It appears so.
Thank you. Using column O as an example, I just want to walk through some things. It's my understanding that column O calculates total revenue for the year 2027. Is that correct? Just using this particular one.
Yes.
Thank you. And in the same column, a few lines above, I see test year of current effective rate case, listed here as 2025. Is that correct?
Can you just point out the row that you're on?
Yes. This will be, row 46.
Yes.
Column no, row 46. So this is for 2027.
And this is, I think, just to point out, like row 48 was the phasing that I was talking about.
Hmm. Okay, so, and what is the current docket timeline of a water company rate case? Is that 200 days?
270, I thought.
So the company would have to close or calculate its 2025 full year numbers, prefer for a rate case, and file it by what date in 2026 to realistically, set the rates for that 2027?
This is based on like the 50% phase in.
I'll speak to what we had in our business plan.
Yeah.
We were always assuming a preparation in like third quarter. So let's say October filing for rates effective in July of the subsequent year.
Okay. Thank you. And would that then work within this model? Would that timeline, from an Aquarion's point of view, preparing for a rate case, filing it, getting the rates in, starting at 2025 and going into 2027, is that feasible, or has that happened, I guess, in the past?
Maybe just, again, this was done to do benefit analysis based on the AWA model at the time versus Aquarion. And again, it was based on, as I mentioned, the seller's model is the forecasting, and it was really designed to compare what the rates would be under the IOU, yes, assuming 6 rate applications during the 10-year period, as compared to AWA, primarily to demonstrate the benefit of the lower cost of capital that we've been talking about, and to a lesser degree, the no income tax, and to a lesser degree, a lower trend up relative to, property tax / pilot. It was really just designed to show that there is a benefit.
Okay, but to show that benefit, you would want to use an accurate model that reflects actually can happen in the future for Aquarion under its current rate making.
And again, we really did feel that we were being conservative to use 6.46%. Recent debt that Aquarion's taken on would suggest that the debt percent is low here, given the current market. And also, the projections that were actually in the model for ROE were above the 8.7%.
So I thought really quick, going back to the equity ratio here, going back to the capital structure. We discussed how the same WACC would be used, but would a higher equity ratio increase tax expense? And does that higher equity ratio used in calculating the projected taxes in this model?
I would have to confirm with the individuals that, the modeler here. But I would think probably not, or if it did, it wouldn't have a significant impact. I think keeping the 646 again is pretty significant to the rate making estimates and the anticipated increase, and that would be a key driver. And again, we believe that was conservative, and that was our intention.
And does this model take into account the requirement that the historic test year has to be the most recent 12-month period available ending at the calendar quarter? I think that's pure regs section 16-1-54.
looking at rows like 40, like 46, 47, 48, there, I mean, there's definitely a lag. There's the test year, and then there's even a lag, like the 50% in 2026 and the 50% 2027 to as far as how the rate increases are modeled in the revenues.
And what is the gap of time between Aquarion's last two rate cases?
Can you ask the question again?
Yes. I'm sorry. What is the timeline between Aquarion's last two rate cases? Was that 9 or 10 years?
Yeah, so there was the last one was the 2013 case and our current one was 2022.
And that was March 2013, I believe.
I'd have to double check. Filing date or decision date? I can get either one.
Filing date. I
Double check.
think it was March.
Yes, March 13 was the filing date.
Thank you. And as we sit here in August of 2025, what's the difference in Aquarion's base rates as compared to those set in the 2013 rate case?
The difference in authorized revenues, what's the question?
Base rates.
And between what periods?
Since the last rate case to now, or the most recent data I have.
Oh, so the impact of the recent decision. It was a slight reduction in authorized revenue. I just need to get to the reopener decision. 1 second.
While she's doing that, just, I mean, there have been increases due to WICA in the Aquarion revenue stream.
Our authorized revenue under the 13 case plus factoring in WICA was at 199.6 million. And the decision in reflecting the reopener decision is 195,658.
Thank you. Would you agree that WICA has helped Aquarion not come in for rate cases?
Yes.
What happened? Thank you. Okay, same exhibit line 48, phase in. This is.
This was from the seller's model based on the timing of the expected effective dates based on the filing. So that's where that was from. I think you're talking about like the 50%, 50%.
So 50% every year, let's say, or if
Yeah,
it's a 2-year.
It was timed, again, just using the, for this purpose, it was using those 6 applications during the
Got it.
10-year period and what the projection was on the phase-in.
So this is in sort of a multi-year rate plan setup here, correct?
Yeah, say so, yes.
Okay.
Yeah.
And then I guess my follow-up to that would be, has a water utility in Connecticut utilized multi-year rate plans? or was allowed to in any Pura decisions?
I'll speak for Aquarion, we have not.
Yeah, I mean, maybe just to clarify, when I said not necessarily a multi-year, but the timing is just spread, like how it's impacting the revenue based on the timing of the rate application within the calendar year and the effective date.
That doesn't exactly. Um, that isn't currently, go ahead.
No, I think what she's saying is if the rates are effective July 1st, we would only see, in a calendar year, we would only see the 50% impact of the full rate increase in that year. So that's what this is trying to do. It's just the mechanics of the model.
Okay, I follow. Thank you.
That's correct. Thanks.
Okay, now, second. Okay, same exhibit. Can we go to the IOU RRQ tab, please?
Say the tab again.
Exhibit one tab to the left. Just having some trouble calculating each year's revenues. Are the revenues from current rate case rate increases effective on January 1st or July 1st? So is this some annualization of the prior year's rate increase? Like this is what we talked about, but I just want to make sure.
I believe so, yeah.
So why isn't, for example, the January 1st, 2027 base revenues equal to prior year's 2026 base revenues plus the 2026 revenue from the current rate case?
I'm looking at the, just going through some of the calculations here.
Okay, thank you.
I think they're, just looking at this, I think you need to look at like 103 and 104. Where it was 103 and 104.
103 and 104. So for 2027, row 104 is showing 15,893, correct? And
That's, year
27.
27, yes.
Hmm. Right.
See, like the 2740 is, driving the 257, 190 versus the 276, 156, which goes up at the top.
Not sure I can get there, but I'll move on with that question. Thank you. And then are the WICA revenues here cumulative? Because looking at the WICA revenues, year one is 768, year two is 776, then year three is 803, but then year four is 6,150. So an increase from 803 to 6,150. Just curious how that's possible.
Think just looking at this, you're not, in that particular year, it looks like there's not a like a base rate increase change. So I believe, your WICA would be, generally higher when you're in between rate cases.
But WICA's but I do see the numbers getting even higher going forward, in the following years. So,
And again, I think it's like how high the WICA is going to be, like when you're building up prior to the rate, your new rate case, because it can go up to 10%.
but then doesn't the WICA get rolled into base rates in the recurring?
It does, yes. And again, I think it's due to how the timing and how the phasing is based on row 96.
Okay, thank you. Okay. Can we move to late file 2 attachment 2, tab A and N debt summary?
Let me have to get there.
Yeah, thank you.
I'm there.
Okay. So I imagine that stands for annual debt summary, correct?
It is in fiscal years.
Okay. So in 2020, I see total debt post-transaction at $2.53 billion. Is that right?
Correct.
And if I look at column U, I see 4.748 billion of debt. Is that correct?
That's correct, because it's, we have the acquisition debt, we do have a lot of capital, so that's building up. And then as the acquisition debt is, getting paid off, it's starting to go down, but it does peak, yes.
Okay. And in what year does the debt peak?
Currently, it would be like 2041.
2041? Thank you. So correct me if I'm wrong, but I believe that in the municipal model, you need to raise rates to then increase the borrowing, or differently, the rates need to support the additional borrowing, correct?
The rates need to support the additional capital, but again, I think a key aspect of how the model works is that as the acquisition debt gets paid off, and we believe like the quicker it can get paid off, actually the better, because there's more monies available, so you're not financing as much of the capital. And towards the end of the model, we're using internally generated funds for about 75% of the capital requirement, because all that money is going back into the utility and none's going out to the equity investor.
Okay. But so generally, you would need to increase rates to then be able to borrow more, correct?
Yeah, Yeah, you need to meet the coverage requirements, yes.
Thank you. So that 4.74 billion of total annual debt is about 15 years from now, let's say, or 16, 15,
Yeah,
16 years.
I mean, there's significant, as we talked about, significant capital. Just in the first 10 years, there's over $2 billion of capital investment required.
So So for those 15 years on average, it looks like the borrowing is going up by almost $150 million per year. Subject to check. Does that sound about right?
Yeah, if you look at like row 20 here, you can see the CapEx debt, we're calling CapEx debt versus the acquisition debt. So while the acquisition debt is going down, the capital debt is going up until, you get, farther out to pay for the capital program.
Thank you. Same exhibit, but let's move to the revenues tab, please. And column D, operating water revenue.
Yes.
So these numbers are on fiscal year basis, correct?
They are on a fiscal year basis, yes.
Yeah. So is the full year
The first full year is 27.
right? So 2026 is just a partial, correct? Yep.
Yeah, yes, very, very partial. Yeah.
And this is for combined AWC and TWC.
It's all in. It does also include Ansonia wastewater.
Okay. So
And I would add, and I know this was in some of the responses, I actually think the revenue, from what I understand about where Aquarion ended its calendar 2024, plus the filing that was made for the October WICA, I actually think the revenue that we're using, starting at the 214, is actually low, which will further improve the model.
okay, but subject to check, would you agree that the revenues allowed in the Aquarion's last rate case were just under 200 million?
Yes.
So, okay,
Without WICA.
okay. And then I'm looking at 531.36 now.
Where are you again?
This is row 28.
On the revenues tab?
Yes, correct. 531.36. So the revenues here are, let me see. Almost the current, almost double the current levels. And by 2046, let's say, they triple.
It's all driven because of the capital investment. I mean, it's significant. And again, this is like all revenue, so no, what would have been WICA is captured here. What would have been under HB 6777 is all capital, is captured here as part of the revenue requirement. But the capital investment is significant.
So by 2042, this is row 34 or so. You see the increase coming down to 4.5%, and then it drifts lower. Is that due to some reduction in new CapEx or just the outstanding debts?
It's actually primarily because more and more is being funded. So existing revenues, can cover the debt, the acquisition debt. You're increasing to cover the capital. But I think the good news in the model is when you get after that acquisition debt is paid off, You're not making, it's all internal to the authority, and more of the capital is being funded through internal funds.
Thank you. Can we turn to late file 18, please? This is a table of rate case increase projections. The first line in this table is showing rate increases for 3 years straight. For 2026, 27, and 28. When was the last time Aquarion received a multi-year rate plan approval from the authority?
When was the last time we what? What was the question?
You received a multi-year rate plan approval.
This doesn't reflect a multi-year rate plan. It reflects individual rate case filings
So,
on an annual cadence.
so annual rate cases?
Correct.
Thank you. And when was the last time Aquarion has filed annual rate cases?
It hasn't because we haven't had the need to in the past.
And what about other water utilities? Can you speak to that?
In terms of an annual cadence,
Yes,
um,
in Connecticut.
I can't speak to that right now.
It's talking about RWA, we do every 18 months.
I think that's it for me, and I believe Courtney also has some. Thank you.
Good morning, Allison McCorney for the Office of Consumer Counsel. I just have a couple of questions. Referring to late file 14, attachment 1. Let me know when you've pulled it up.
I think, Dan, this is.
Yes, I'm all set.
Okay. Were any of these projects completed for reasons other, or not completed, I shouldn't say. Are any of these projects done for reasons other than PFAS?
So sometimes there's a combination of reasons. The Pleasant View system that was interconnected to New Milford was done due to lack of water supply as well, as an example.
As an example, so those wouldn't be the only two, but that's the type of reason that.
So, yeah, so it had PFAS and it had Pleasant View didn't have enough water supply during the summer, so we were trucking water. So we did that one. Butternut is going to get an upgrade related to chemical treatment, so that's a combination project. So the PFAS will be added to that project because it needs a general upgrade to the facility as well. I'm just looking at the list. And Newtown Wellfield is the same thing as Butternut. We need to do an upgrade to the chemical feed systems. So we're building a new building, so the PFAS will be part of that project. So we're trying to combine those things so that I don't end up having two projects that cost more.
Okay, thank you for that. That actually brings me to another question. You had mentioned Butternut, and I see that it's listed under project status as alternative analysis. Could you tell me what that means?
Yes, sure. We go through in our process, an alternative analysis means we're evaluating whether we're going to interconnect it to another system, add treatment, or take another step, abandon the source altogether. So that's when we're looking at different scenarios of what might happen and trying to develop the solution which we will implement at that stage.
Okay. Thank you. Are some of these projects required due to the acquisition of smaller, maybe troubled systems? Like, are the interconnections for any recently acquired systems to existing Aquarion systems?
And the recently acquired systems would be Plainville and Torrington. which are not small systems, obviously. If you would look back, you might see some smaller systems that were required historically that are being either interconnected or treated, but nothing recently.
Okay. Are the scheduled completion dates listed the same as in-service dates?
Just looking at it for a second here.
Sure.
So in service means that the treatment is in service, but there's not necessarily complete. We may have a punch list, a generator, you can see the notes. So it will be considered T-code at that point as it's in service, but there's still more work to do on the facility itself.
Okay. For all the projects, is Aquarion going to meet the treatment deadlines for PFAS?
Yes, that's the plan we've laid out.
Okay, thank you. Turning very briefly to late file 15, attachment 1. That's just a reference. I don't know if you actually need to pull it up. How does RWA decide to raise the OCA budget?
Are you talking about in connection with the acquisition? Is that?
Generally, so the late file 15 attachment 1 lists fiscal years from 2017 to 2026, as well as the annual budgets for the OCA. And I see they changed from, about 50,000
correct.
to, how does that? decision
So
come about?
the Consumer Affairs Committee is the committee that reviews the OCA budget before it goes into the official budget process. So this was, you can see that there were some increases, including between 18 and 19. It went back down slightly, primarily because the actuals, demonstrated that there wasn't a need to bring it up to the 62,500. But the process is that the Consumer Affairs Committee is the one that signs off on the budget. And then, like I said, it goes into the official budgeting process.
Okay, so you would say that there's a review of the budget?
Yeah, there's
okay.
there's definitely a review.
Okay. Has the OCA ever requested to increase its budget?
Well, you can see that there has been increases, and I believe this was a response to another interrogatory. This includes the OCA hours. It does include some dollars for expert consultants. Sometimes there's expert consultant budget within the OCA budget. There's also one within the RPB budget. So, and you can see that there has been, like I said, an increase. It's been pretty consistent now at the $60,000.
Right. I guess I'm asking whether an increase has ever been at the request of the consumer advocate.
I'd have to think back, but I would say probably so, although not from the hourly rate. Again, it depends on if it's anticipated, and sometimes it's known, going into the budget, if there's a project that, it's definitely expected that there's going to be an outside expert needed that can play in.
Okay. All right. Thank you. I think that's all we have from the OCC. Thank you.
Thank you. Attorney Nigro, please.
Chair Gillette, we have a update on 31.
Please.
So we confirmed that late file 31, which if you remember was the annual reports of RWA, and it's about 24 attachments. They were emailed to the service list on Monday, as well as to Mr. Gaudiosi on Monday. We're working with Ermelina Flynn to make sure that those are posted properly to the website. We apologize for any inconvenience.
Thank you. And I think the commissioners did get an email while cross was happening. So I believe
Great.
that's been resolved. Thank you.
Good morning. I'm Susanna Nigro from the Department of Energy and Environmental Protection. If I could please turn your attention to late file Exhibit 8. In that exhibit, there are two tables, and I want you to look at the bottom table, please. You could let me know when you have it. Thank you. In the second column, it says total all, and I was hoping you could clarify for me the costs, the individual costs that were added together to total that column.
Yes, so the, going back up to the first table, that just provided the cost related to full-time employees as the request. And then the second table adds in some part-time officers and rangers that were in place during those years. So the dollar delta between the two tables reflects the cost associated with those part-time employees.
And what categories of part-time employees were included in that?
One sec. In 2020, the tables go through 2020. Okay, so in 2020, there were 3 part-time officers included in that. 2021, 3 part-time officers. 2022, there was a change during the year. We started the year with 3 part-time officers, but for the second half of the year, we only had 1 part-time officer and a part-time ranger. In 2023, we started the year with that same part-time officer, but ended the year with no part-time officers and 3 part-time rangers.
Okay. What I'm going to ask you to do is to please revise that table to itemize it for the different categories of employees and the expenses related to those specific categories. Thank you. Then if you could please turn your attention to Exhibit 9, which is an RWA exhibit, please. In 2024, how many officers did RWA employ?
I believe we have close to 5 officers.
Okay. And how about in 2023?
23, maybe less than that. We kind of increased the officers as the years went along. And there were people who went, retired, resigned, and then we had to increase the officers. So on average, I think during 24, 25, we have about, say, 5. And prior to it, it was about, say, 2 to 3.
I noticed there was a jump in the total cost between 2023 and 2024. Is that based on the number of employees, the number of full-time officers you had?
Primarily, yes.
Okay. And why is the reason that you increased the number of full-time officers?
There was a request from the governing boards to see how we can effectively increase security around, I would say, the 28,000 acres that we have. Based on the request, there was a detailed study that was done, and that study yielded that there could be more security measures which were needed, and that's the reason why we increased the officers. And there was significant input from the Land Use Committee, which is the RPB, and the overall Representative Policy Board as well.
Thank you. Would it be possible before the close of the record to produce that study?
I believe so, but I'm not so sure whether it could be protected, but I think, council, we will check with the council. And see.
Thank you. If I may.
I'm sorry, Attorney Nigro, you're looking for them to supplement their response with a copy of what study?
It was a study done on behalf of RWA concerning the need for an increase in law enforcement. Is that correct?
And which late file exhibit is this tied to?
It's tied to Exhibit 9, please.
Okay. Is that something the company or RWA is prepared to do?
I think we can accommodate that request. It is a late file exhibit hearing, this rolling discovery, I think gives us all concerns, but we understand the record's open until next Friday. We'll do our best to supplement late file 9 as requested by Deep.
Okay, thank you.
Thank you. And then if we could move on to late file exhibit 10, please, attachment 1, which concerns paid police details for Aquarion. Thank you. How many municipalities does Aquarion contract with for these police details?
I do not have an answer for that.
Okay. Are the location?
Sorry.
Are the locations where these officers work limited to the boundaries of the municipality that they're contracted to work from?
Yes.
Okay. And just to confirm that the officers described in attachment 1 are not commissioned under Connecticut General Statutes 2919.
That's correct.
Okay. Well, thank you. I have no further questions.
Thank you. Attorney McCormick.
Good morning, Caroline McCormick on behalf of the Office of the Attorney General. I have some questions on the OCA. Referencing late filed exhibit 15, attachment 1, why was the OCA budget increased from $50,000 to $62,500 in 2019?
This is solely from memory, but I believe it was at the time that we put money into the budget for the expert consultant that may be required. Again, that's from memory. Okay, subject to check.
So to confirm, you testified in the evidentiary hearings that the budgeted annual cost for outside consulting is $25,000 shared between the OCA and the RPB budgets, correct?
Right.
Now is the split $12,000 being paid by the OCA and $12,500 being paid by the OCA and the other $12,500 being covered by the RPB with the final OCA budget to Attorney Donofrio being $47,500?
So the 12,500, the budget's done that way. So it's like split, and it depends on whether an expert is actually used and who would actually pay for it. But the budget's split, so they can both avail themselves of the expert.
So what happens when an expert isn't hired for a year? What happens to that $12,500?
We underrun the budget.
Now looking from 2021 to 2022, there was a drop in $2,500. What was that?
That was actually because the actuals were have been running lower, and so we just reduced it by that, small amount. Again, the Consumer Affairs Committee would have concurred with that.
Okay. Now moving on to late filed exhibit 6. The OCA has only engaged 2 consultants since 2020. Is that correct?
That's correct, since 2020.
Now, if the OCA wants to engage a consultant, does the OCA have to have this request approved by the Representative Policy Board?
Not to my knowledge, no. because the budget's there for that use. And so like in the cases that were, where he used the expert, it was a large capital project with a new CIS, and he engaged two experts to help him, go through the application and reach his decision. So in that case, the OCA, hired the two consultants.
So the OCA doesn't have to go up to approval for engaging a consultant, is that correct?
Not to my knowledge, no.
What if the OCA wants to go over the budget in hiring consultants? Does the OCA then have to go and receive approval?
We haven't had that situation. Just based on how I would expect that to go, he would be allowed to do that. Sure, he would concur with Consumer Affairs to get their concurrence, but I wouldn't expect it to be withheld if he felt that that was necessary. It hasn't actually happened.
Okay. So if the OCA doesn't need approval when engaging consultants, the OCA can just engage consultants. Did the OCA only request 2 expert consultants, or did the OCA only take on 2 expert consultants since 2020? There were no requests for additional consultants.
That's correct.
And so then just to confirm, the OCA hasn't engaged any expert consultants in any rate applications since 2020. Is that correct?
The OCA hasn't, I believe that we referenced in the late filed exhibit, management does use a national recognized firm when we do cost of service studies. We also discuss with our consultant rate structures, and and from time to time we'll just reach out for other like regulatory rate questions that we have. So management does use this consultant. Again, every time we do a cost of service study, it is done by a nationally recognized firm. And we expect that to be the case with AWA.
And who is doing the reaching out? It's management, or
It's management. But the OCA is aware that we use this firm.
okay. And has the OCA ever engaged any consultants, accounting consultants or otherwise, in any rate applications?
Not since I've been with RWA, but again, we have had this, it's Reftelis Financial Consultants, Inc. I don't know if anyone's heard of them, but they are well known. And that individual has actually spoken, the consultant, with the RPB from education. The OCA has, has exposure to him. I'm just thinking about a situation where there was questions about the rate structure. And so our OCA was involved, the consultant was involved, I was involved. So there is, I would say there's interaction.
Okay. Now moving to LFE 16. And please let me know when you're there.
I'm there.
Great, thank you. The amendment to the bylaws/rules of practice action requires a majority of weighted votes of the entire membership with 5 days advance distribution of the amendment, correct?
Correct.
Now, I don't see that advance distribution of the rate application is required in the vote required column of the chart. Is that correct?
Can you just repeat the question? I just want to make sure I understand it.
Yes. I don't see that the advance distribution of the rate application is required in the vote required column of the chart. Is that correct?
That wouldn't be a vote. So for a rate application, or for that matter, any application, it goes, it's presented to the authority board. If they're not voting, but if they're okay with it being sent out, it gets sent out. And then there are certain windows, not a vote, but there's windows that need to be met between like that I believe it's 5 days, subject to check, between when, let's say, an application goes out to the RPB and when the minimum time before a decision is required. And that decision can be as simple as, not as simple, but an example or straightforward as, yes, the application is complete and the hearing can get noticed.
Okay. So then for the final disposition of the rate application, if the board members vote, if any board member votes no on the rate application, does that board member have the opportunity to explain their no vote?
Are you talking about on the final decision?
In the final decision, yes.
They do have an opportunity to explain their no vote.
Has that been done in the past?
It has been done in the past. It's not always done.
Okay.
And that's not just on a rate application. If a RPB member votes no, even on a capital project or an acquisition, as an example, they have an opportunity to explain. And there's discussion before the vote. I mean, there's presentations, there's questioning, there's discussion. And there is usually, unless the decision is expedited, but usually there's just about a month between when the hearing happens and when the decision is taken.
Okay, thank you. Now, moving on from the OCI, I'd like to turn your attention to late filed exhibit 2, attachment 2. And please let me know when you're there.
I'm there. I'm not sure what tab.
Can you flip to the revenues tab, please?
Yes.
Great. So I see the last column of the chart includes the heading Synergies. What is Synergies made up of here?
Synergies is made up of estimates that we got from due diligence as to, opportunities in the AWA structure to have some savings. And I think we responded to this. So we have, and the report was filed confidentially, and it talks about what these savings could be. Believe we also said on the record that, we're still evaluating, but I'm going to provide an easy, straightforward example. Just not being a publicly traded company is actually has some benefits. And we're comfortable with keeping these synergies because we did through the process lower the synergy assumption based on the due diligence report. So we believe that they're reasonable. We're continuing actually to work with the firm on further vetting to help ensure that the synergies are achieved.
So was the Synergies calculated with the help of that firm?
It was. I would say it's not necessarily exactly what was in the report, but the report definitely supports the amounts that we've included.
Now, were those filed confidentially, or what are those components that make up the Synergies tab?
The due diligence report was filed confidentially, and it does show calculations. I do want to be transparent in saying those are not necessarily how we're going to end up achieving them. There could be other things that we will use to meet those targets, including, as we talked about, combined purchasing power.
So I understand that the due diligence report was filed confidentially, but the components that make up Synergies, is that confidential as well?
We would like to, yes, we'd like to
Okay.
keep it confidential.
Thank you. Those are all my questions. Thank you.
Okay, let's transition into cross Attorney McLeod, please.
Good morning, Madam Chair. Ms. Sabo, I believe that in Mr. Sarah's prior testimony, she said with respect to the 5-year plans that you do every year, that they are essentially a months-long process. Does that sound correct?
Yes.
And again, this is my recollection, so if I'm wrong, please correct me. I think she also said that the process begins, I think it was a month in spring. I'm going to take a stab at, say, April or maybe March. I'm not sure. Can you tell me, maybe verify what she said?
Yes, I mean, typically they start around the March timeframe and are finalized in April, May.
They're finalized in April. I thought she had said that the process actually went until perhaps September or so, but
So there's 2 steps that happen annually with regards to planning. We have a 5-year plan that's done in the spring timeframe, which would be, commenced sometime in the first quarter and usually finalized in April or May. And then commencing in September, we have our annual budget for the coming year.
is the September step one in which it's possible to make changes to that plan? I mean, is that
Yes,
one more chance at
yes.
maybe revising or updating or whatever?
Yes, the 5-year plan, like I said, it covers, a broad period. It's done early in the year. So as you get further along in the year in September is when we would revisit the assumptions for the coming calendar year
Okay,
and make any necessary changes.
thank you. Ms. Kowalski, with respect to LFE 21, if I read that correctly and your response in there, it is based on total acquisition debt of 1.8 billion after a reduction of 500 million. Is that the model represented in LFE 21?
Yeah, that's the hypothetical model, yes.
I understand that. With respect to the amount of debt, I know we've had this discussion before where there was a $2.3 billion figure, which I think is represented in this model here in LFE 21. But there was also a figure of 2.61 given in the sources and uses table, which was provided in attachment 1 to COG 46. And I think you testified when we were last together that that was an updated and perhaps more correct number.
The 2.6 number includes the initial capital investment, which is not part of the acquisition debt. I think so when we're talking about, let's say the 2.3, including, cost of issuance and such, does not include that capital investment.
Do you have,
It does.
is there an acronym for capital investment in your sources and uses table?
I think it says initial capital. If you give me the number, I can.
Well, maybe I can be more direct. You have an entry in the sources and uses table as well as in the LFE 21 and OCC 42. CAPI, what does that stand for?
That's that's capitalized interest. That's actually, that's not just the capital. It's a very small portion. We're using that capitalized interest concept to help us build liquidity in the first couple of years. But
Okay.
the capital, and if you actually,
And that goes for both? I mean, the original OCC 42, you had the CAPI and also in this LFE 21, correct? That's consistent.
yeah, I need to check it. I don't believe we adjusted it even in the LFE 21. But just to clarify, in 21, it doesn't have the whole 2.3. It has like the 1.8.
Yeah, I wasn't really probing on the figure so much as I was the fact that you do include both.
Yeah, and it's a tool to build liquidity. I will just mention, depending, and as we said, the actual debt structure and of course the rates will be based on the market conditions. So we may or may not need to do that capitalized interest. But at this point, based on what the current rates are, it helps build liquidity.
So getting back to the difference between the 2.6 billion figure and the 2.3 billion, the way you have done OCC 42 and LFE 21, both of those are consistent with your reference to 2.6 as the total acquisition debt and 2.3 nevertheless still being the appropriate debt amount to use in these tables?
I just want to clarify, so we're not talking past each other. For the hypothetical, the 1.8, it doesn't include that extra 500 million, which is how we interpreted the
Understood.
question.
That was the point of the light filed, and thank you for that. I want to also make sure I understand, given the difference between fiscal and calendar years, given your fiscal year, which I think is a June 1 year,
Correct.
would a rate increase in September 2026 be considered a 2026 rate increase for Aquarion and a 2027 rate increase for AWA?
That would be correct.
Okay.
Yeah, if it was the same date, yes. Yeah.
Yep.
Yeah, so if it was September 2026 would be fiscal 2027 for AWA, it would be fiscal 2026 for.
And is that what listed in LFE 21 when you have years? I think you would have.
So fiscal years.
Yeah, okay. Just comparing OCC 42, I'm going to spare us saying attachment 1 every time, okay? I'm referring to that on both. So comparing OCC 42 and LFE 21, it seems to me that the existing system revenues are the same and the operating expenses are the same. This is at least through 2035, correct?
Correct.
And basically the only difference in total revenues is due to minor differences in occasional years in interest income.
Yeah, interest income is slightly different just based on how the model is working, yes.
Okay. And you might have to check my math, but it seems to me that when I added up the total debt service in both through 2035, The total debt service for the $2.3 billion amount shown in OCC 42, or on which OCC 42 was based, I should say, came out to 1.362, excuse me, .362 billion. Total debt service for the OCC 42, the 2.3 billion figure, and a higher figure of 1.379 billion for the $1.8 billion debt.
I'm not sure I followed all the numbers, but just conceptually, the 1.8 does have, if it really was 1.8 instead of 2.3, the acquisition debt would get paid for quicker. Like we talked about, that's a positive thing because the quicker the debt gets paid off, the more money is available to put into the system. And you could see that at the outer years of the 1.8, it allows for more internally generated funds to cover the capital investment in the outer years. So if it was really 1.8, we would actually have an opportunity to amortize the acquisition debt even more quickly.
You said in the narrative portion of your response to LFE 21 that this is a hypothetical model. Does that suggest that you could have varied the terms of the model a little bit to achieve, say, a faster amortization, or on the other hand, perhaps lowered rate increases and a slower amortization that's more akin to what was in OCC 42?
So using the term a hypothetical was to point out that since the price is not 1.8, it's 2.3. To your question, you could do multiple models with different assumptions. This model was done consistent with the approach that we're using, like in OCC 42, where you're optimizing, and optimizing means that you're funding your capital program, but you're also looking at everything in totality, and you're trying to amortize the acquisition debt actually really as quickly as you can within the available CFADs, because as we talked about, the quicker the acquisition debt is fully amortized off, the more money is available to take those CFADs and use and invest back in the system. And in the AWA model, as we've said, there's no equity investor that is taking any of those proceeds.
I take it that optimizing is in several ways a judgment call. You're making judgment calls as to what would be best for this, that, or the other number of factors.
I would say yes, the optimization in the model, I'm talking about OCC 42, is based on input from our key lender, as we mentioned, as well as our financial advisor that we use.
Could you have chosen with 500, could you have chosen with 500 million lesser debt to instead have come up with a model which lowered the number, I won't say the number, which lowered rate increases and revenue requirements rather than opted to pay off principal faster?
We could have, as you said, you could develop various models, but that's not what we would believe would be prudent and in the best interest of the customers.
So I guess taking that another step, there is always that factor present in a rate model that you use in rate increase requests. Kind of a choice between getting a little more money in so that you can pay something faster or take care of another laudatory purpose at the expense of something else. You make those judgment calls in the,
Would say within a range, yes.
okay. I noticed the operating expenses, we mentioned this, are the same throughout. Is executive comp an operating expense?
It is an operating expense.
What assumptions were made in the operating expenses set forth in LFE 21 regarding executive comp for executives who would be shared, who would have similar positions with both RWA and AWA?
There was no explicit adjustment for any compensation adjustment. For those situations, the model for both 21 and 42 came out of our due diligence work, including, as I mentioned, like we adjusted up like insurance, we made some other adjustments. We'll continue to, as we're, working together in the process, moves forward, we'll be further and further refining the models, but there's not an assumption that those executives that you're talking about are going to get, some compensation, additional compensation.
Was an allocation made in those operating expenses between RWA and AWA?
Not explicitly.
Okay. Implicitly?
No. I mean, there were so these models, both the revenue and the expenses go back to due diligence. To be conservative, we did not adjust the revenue up, as I mentioned, based on how Aquarion ended the year with the Ansona acquisition, with an anticipated even 10-1 WICA. We, again, wanted to be conservative. We do tend to be conservative in our estimates. We kept the revenue the same, partially because, we don't want to increase the revenue without revisiting the expenses. So we left the revenues, at the same level that we used back in October when we were finishing up due diligence.
I believe you said probably more than once that the rate structure of AWA has to await the outcome of a cost of service study. And I also think that you had said that RWA's residential rates are uniform throughout the RWA service territory?
Yes.
Residential.
Yeah, we don't actually, our structure at RWA is not by class, it's by meter size, but it is uniform across the whole district.
Okay. Is there any thought of, if justified by the cost of service study, adopting that uniform structure in the Aquarion service area?
I think we definitely would want to look at the outcome of the cost of service study. I don't remember the particular interrogatory, but I think an aspect of our response was, let's say the cost of service study did suggest there needed to be adjustments. Our anticipation is it would be done gradually. That's also tends to what RWA does. So there's not a immediate significant, increase based on what the study suggests.
Okay. Do residents of land towns in RWA pay or contribute anything, rates, fees, or otherwise to RWA?
I wouldn't say they contribute. If there's, there could be, I would have to double check possibly some, like public fire, aspect depending on the distribution pipe.
Hmm.
But
So there are towns in which you may not have water customers per se, but you provide fire service in RWA.
can you give me a minute to check that? It might be quicker if it's okay and I do like a read-in later. I just want to check if that's the case.
I'll withdraw the question. Is it fair to say that Killingworth and Guilford are towns in which they're land towns where
They're
you do
land
not
towns.
have water service?
There are land towns.
Okay. Mr. Lakshman, I had this down. Mr. Lakshminarayanan, since we were last together, have you had an opportunity to discuss with either board members or committee members or fellow executives the prospect of adjusting the board composition?
I mean, we have actually considered all the concerns during the last three, I would say, hearing days.
Since the last hearing date?
No, the last three, I would say, the 24th, the 28th, and the 29th. We heard all the concerns that most of the interveners had brought up. Subsequent to it, we are actually working through, bouncing off ideas with the board members as well to see what we can actually collaborate in a fashion with the OCC's office, the AG's office, as well as the intervening towns. So that process is ongoing.
Is there any sort of time frame for that?
Currently, there is no time frame as such, but we would like to work in a very, I would say, a fashion that is more, I would say, desirous of us, the board, as well as the towns and the rest of the officers who represent it.
I'm sorry, I think I missed the verb in there.
Yeah. At this point, there is no particular time frame as such, but we would like to kind of work towards an expedited way where we can actually, kind of collaborate with all the intervening towns as well as the OCC's office and the AG's office and, DEEP, et cetera.
Toward an adjustment of the board composition?
Not necessarily, I would say, just the board composition, but I guess, we could look at, I would say, a whole range of concerns that were brought up. So I'm not particularly touching upon the board composition itself, but I think there were other concerns as well we heard. So I think overall, holistic, I would say, an approach to look at the many concerns that were brought up. That is part of the ongoing discussions.
Well, are you aware that there was a legislative effort in early 25 to repeal 24-1?
Yes, I've heard about it. Yeah.
Okay. So I asked that question in part because I think RWA's support for a legislative change would be important, and I hope you would agree with that.
We believe, I would say, as we did last time too, we worked closely with the legislators even during the special session. We had actually, I think, Rochelle will confirm this. I believe there was a vote that was done. And all I would say, all the changes that we do during any enabling legislative change, RWA works very closely with, I would say, both the houses. And we work with.
It works closely with whom, I'm sorry?
With the legislators.
Yeah. I have no further questions, Madam Chair. Thank you.
Thank you. Let's take a break. 5 minutes, 10 minutes. Let's take a 5-minute break and when we'll resume with Cross from NAWC, please. Okay, I think we are all back, so we can go back on the record and docket number 250403. Attorney Miranda, please.
Thank you. Joey Lee Miranda from Robinson and Cole on behalf of the National Association of Water Companies. Good morning, everyone. I have a couple questions following up on some testimony from today to start. There was testimony regarding late file exhibit 2. I don't think we need to turn to it because it's a very general question. But there were questions about various components of the things included in late file exhibit 2. And my understanding from the testimony is that or at least my understanding was that the only change that AWA made to the seller's model was to maintain the 6.46% WACC. Is that correct?
No, that's not totally correct. I think there's two different, there's the attachment 1, which I think is what the first questions were this morning. That's a calculation that was done by our M&A advisor on the savings. And so for that modeling, the adjustments that were done is instead of just using the seller's model as it was, there was an adjustment to keep the authorized return low, to be conservative at the 646 throughout the entire 10 years. There was also a adjustment for the comparison to use the same capital that was in the AWA model versus the seller's model, because there were some differences. And that was mainly what that analysis was to show. And it was basically to show this is an IOU, right? And this is AWA, and that there are savings. There are savings that are coming from the lower cost of capital. There are savings that are coming from no income tax going forward. And there are savings also coming from a smaller but still increasing projection for a pilot versus property tax.
And so then that's late file exhibit 2, attachment 1. OCC 42, that model, is the only change, the weighted average cost of capital, or are there other changes in that
No.
as well?
So, so late file exhibit 2 is actually the same forecast as OCC 42. However, there was a request to provide a lot more detail, like all the detailed schedules. So that's what we did. That model is based on the due diligence. As I mentioned, I think a few times, the base revenue start point in the model is probably low based on what we know today, but we decided to leave it. The pilot there is the lower trend that we talked about. There were some interrogatories about that. So it has a 3.5% year-over-year increase versus the increase that was in the seller's model. It has our, I think, reasonable synergy assumptions. And then for operating expenses, it does have some due diligence items that came up that we adjusted for.
Going to the synergies, in late file 2, attachment 2, under the revenues tab, there was a reference to the synergies. And I believe the testimony today was that you were still evaluating those, but the fact that the AWA was not being publicly traded has some benefits, and that those are captured in the synergies?
They would be an example of the synergies that will support those numbers. And again, we confidentially filed the due diligence that was done, supporting that what we put into the model were reasonable assumptions.
And so doesn't the rest of the model already account for the fact that they're not publicly traded and that they don't need a weighted average, that you won't have the weighted average cost of capital and all of those issues?
Two different things. One's just an adjustment to the operating expense, right? So the synergies are modeled as a relatively small adjustment to operating expense. The rest of the model, absolutely fundamental to this, is that under the authority structure, there are other savings, including that we don't have an ROE, that our cost of debt is lower. Those are all factored in and help demonstrate the public benefit of an authority model.
In response to questions from the Attorney General's office regarding late file Exhibit 16, you were asked if advanced distributions required for rate application, and then there was some testimony related to that. And my understanding of the testimony, or what I wrote down, was that any application presented to the authority board, then if okayed by the board, gets sent out. Do you mean the application is okayed, or the sending out of the application is okayed?
The sending out of the application is okayed. So I think may have come up even in earlier discussion. The authority board is not voting. They are supporting the sending out of the application.
So let me back up. If the application, once it's, let's call it final. So it sounds to me like what could happen is the authority board could look at it, have input, and then it could change, but ultimately the final material is sent. Is that right?
Absolutely.
Okay, thank you. In response to the cross from MetroCog, you were asked about CAPI, which is capitalized interest, and I understood you to say that was going to be used to help build liquidity in the first couple of years, and you may or may not need to do it. Is that right?
Yeah, the CAPI, and this is not CAPI from an accounting perspective, which is to some degree different. This is actually using a financing mechanism to help build liquidity.
And when you say help build liquidity, does that basically mean that the rates are higher to cover the capitalized interest so that there is additional cash available?
It means that the financing that's already built into the assumptions, is allowing for money to be put aside to, just in those early years, to help mitigate the debt service payment.
So it's not interest that'll be used in the year it's collected. It's being put aside to be used in future, to pay future years.
It's modeled as it's going to be paid, and it's just in the first couple years, and it's really to help build liquidity. And again, it depends on what the final rates are if we need it. But I think I mentioned, and it's probably in some of the other exhibits, the available cash that we're expecting to get at closing is relatively low, and that we want to, very low, and we want to actually have a mechanism to bring up those days cash on hand.
And so again, the money that would come in under this CAPI would not be used in the year it's collected to pay interest. It would be put aside for use in future years.
It's right in the model. So if you go to the model, it's most of it is actually being used in 2027. There's a portion that's being used in 2028. And then there is no longer a need to do the CAPI.
Well, so I want to back up. So when you say used and when I say used, we may be talking past each other. So when you say used, you mean collected, correct? And when I say used.
I mean, not collected. Now, this is part of the upfront financing. It's actually built into, we provided, and I think we provided this previously under OCC 42. It's again in late file 2. We have the different aspects of the financing, and this is incorporated into the capital expenditure bonds do include the amount that we're going to be putting into that. Just call it an escrow fund for lack of another word.
So the escrow fund, maybe this is the way to get what I'm trying to understand. The escrow fund will be the monies that will fund the escrow fund will be collected in 1 year and may be used in a subsequent year or 3 years later or 5 years later.
When we expect to use it is on that forecasting projection page. And so for the Cap I, it's 2 years, and for the escrow, it's actually in a few of the years. And again, if the rates continue to go down like they have actually been going down, at least in the last week or so, we may not even need to do that.
Okay, turning to the late file exhibits, starting with late file exhibit 1. It indicates that the debt structure will be based on market conditions at the time. In fact, you were just discussing that. And you indicated that a reduction in interest rates prior to the transaction closing would result in lower financing. The opposite is also true, correct? That an increase in interest rates prior to the transaction would result in higher financing.
That is also true. As we've also talked about, we're monitoring what the rates are. We also indicated in a prior interrogatory that if the rates actually went down low enough, we may even choose to hedge or partially hedge, but we're watching that closely. We're in constant contact with the bankers and our financial advisor. Like I said, the good news is the rates are, have been down a bit since we even did the model. But yes, things can change. As we have also said, the model doesn't even include any further refinancing, which we've also responded that RWA does pretty frequent refinancings, and we would expect that AWA would do the same. And we've also built in 10-year par calls, which RWA also does with possibly an opportunity to do certain maturities even at a lower call date. And that doesn't preclude doing like tender refinancings, or even if the rates go down low enough where taxable is in a future year actually lower than what the tax exempt is at the time of closing, that can happen. There's nothing that precludes us from doing a taxable refinancing.
Turning to late file exhibit 2, attachment 2, the forecast tab.
Can you repeat that?
Late file 2, attachment 2, forecast, open parens, annual, close parens tab.
So that's the same sheet as was filed in OCC 42.
And so my question is that on row 12 under 2026, it indicates that there is 82 million in existing system revenue, correct?
It's a partial year. It's like 4.5 months.
Okay. I know the numbers probably aren't all that critical to the question that I want to ask. And then if you go down to row 45, there's the total capital expenditure of 255 million, correct?
That's correct.
Okay, and so from where is that CapEx being funded? Is that part of the 2.61 billion that you were
Yes.
discussing with
Yes.
MetroCog?
Yes.
Okay, thank you. Late file exhibit 7 provides the regulatory costs being incurred by AWA and Eversource. From Eversource's perspective, do you expect to receive recovery of those costs in your rates? Thank you. Late file exhibit 21. The response indicates that acquisition debt will be amortized more quickly than capital investments, intended to free up money on an earlier time frame to enable funding of a higher percentage of capital expenditures through internally generated cash. The acquisition debt is being amortized over 40 years. Is that correct?
It's over 40 years in with the actual amount of debt, like OCC 42 and late file 2. Yes, but its average life is 16.82 for senior debt and just under 20 years for the subordinate debt, which we think is actually, especially given the current rate environment, is pretty quick. That
Late file 22, attachment 2. This is the RWA Code of Ethics, correct?
we have, we.
Attachment 2?
Yeah, attachment 2, and then we also, just based on things that were also just in our regular employee handbook, we thought it was appropriate to include that as well.
And that's attachment 3, I believe?
Yes.
Okay, I'm going to get to that. But right now on our late file exhibit 22, attachment 2 is the RWA Code of Ethics, correct?
Correct.
Okay. On page 4, actually, let me just back up for 1 second. A more general question. Do you expect that the AWA will adopt a similar code of ethics?
I expect that it will adopt, yes, a similar code of ethics.
Okay, thank you. On page 4, there is reference to an RWA ethics official. Who is that?
It's our head of HR.
And will the head of HR for the RWA be the head of HR for the AWA, or will they be different?
It's expected that they'll be different.
Also on page 4, it indicates that the code of ethics applies to all employees as well as members of the RPB and the authority board. Is that correct?
Correct.
Okay, but on pages 5 to 6, there are numbered items, 1 through 4. Do you see those?
Not yet, because I'm having trouble opening the attachment. Go ahead.
All right, so on pages 5 and 6, there's items numbered 1 through 4, correct?
Correct.
Okay, and items 2 through 4 only reference employees. Does that mean that those requirements are only applicable to employees, or are those requirements also applicable to the RPB and the authority board?
They are actually, all members of the board as well as employees sign a, like a conflict of interest code of ethics, compliance form annually.
I understand they all sign a form annually. My question is, are the items 2 through 4 applicable
Yes.
just to employees or to both?
But-
Can I finish just so the record's clear? Or to both employees and to the representative policy board and the authority board, in this case, the RWA being the RWA, RPB, and RWA authority board?
Yes.
Okay, thank you. Late file exhibit 22, attachment 3 is the RWA employee handbook, correct?
Correct.
Does this only apply to employees, or is this also applicable to the RWAs, RPB, and authority board?
I would have to go through it individually. It would be primarily geared to the employees.
And the authority, just to be clear, the RPB are not, members of the RPB are not employees of the RWA, correct?
Correct. Or is the authority board, they're not employees.
Okay, great, thank you. LFE 23, attachment 1. These are the RPB rules of practice, correct?
Yes.
Okay, when acting on behalf of the AWA, will the RWA, RPB be bound by these rules of practice?
Yes.
Okay, and do you expect the AWA rules of practice to be similar to these once adopted?
We do.
Thank you. Under the rules, Article 1, Part 1, Section 2, definitions.
Can you repeat that?
It's so it's Article 1, Part 1, Section 2.
What pages?
Hold on.
2.
This is LFE 23. There aren't page numbers specific to the exhibit, but there are page numbers on the bottom. So we are on page 3.
Okay.
Okay, so on page 3, there's a definition for an issuance test rate application, correct?
Correct.
And then there's a definition for maintenance test rate application, correct?
Correct.
And then there's a definition for rate application, correct?
Correct.
Okay, and so rate application, the broader term, includes the first 2 terms, issuance and maintenance rate test applications, correct?
It actually, an issuance test rate application, which is the type of rate applications we've had since I've been with RWA, and I believe previously, it just means that you're incorporating into that rate application is a debt issuance.
Right, I understand that. My question is not about the issuance test definition, it's about the definition of rate application. So the rate application definition includes the issuance test rate application, correct?
Correct.
And it includes the maintenance test rate application, correct?
It's again, just to try to be clear, is that if there's debt is part of the rate application, it's called an issuance test rate application. If there was no debt issuance and you're only trying to recover like operating expenses, it wouldn't be called the issuance test rate application, it'd be called the maintenance test rate application.
Okay, again, didn't ask about the definitions, the question of those documents. The question is a maintenance test rate application included in the definition of rate application?
There is a maintenance test within a rate application that includes the debt issuance, yes.
Let me try it this way. On page 3, item R, quote, rate application, end quote, means any issuance test rate application, any maintenance test rate application, or any other application for an increase or decrease in the authority's rates. Did I read that correctly?
Yeah, that's
Thank you.
called the rate application, yeah.
Yes, okay. So the rate application includes any other application for an increase or decrease in the authority's rates. In addition to an issuance test and a maintenance test, what types of increases would be necessary? What kind of rate application would be necessary for an increase?
We haven't, since I've been with RWA, we haven't had any other types. I suppose an example is, to be transparent, the RPB several years ago did approve a small surcharge under certain criteria and up to only a very small amount. So like if there was something totally unexpected that you had no other way to recover, there could potentially be like a surcharge rate application, but that has not happened since I've been with RWA.
And it indicates that it's for any other application for an increase or decrease in the authority's rates. Did I read that correctly?
Correct.
And has there ever been a decrease in the authority's rates?
Not at a total level, no.
Thank you. Under Article 1, Part 4, Section 21, I'll give you a page number in a second. It appears to be on page 10 of the document. Under Section 21C, there is a time period in which a decision is to be made, and if it's not made in that time, then it's deemed approved. Is that correct?
It's correct according to the rules, yes.
And is that true for rate cases? Rate applications of any kind?
It would technically be true. It's not happened, but yes, and keeping in mind with decisions of the RPB, there is a subsequent appeal period.
LFE at 23 attachment 1, also still the same document essentially, the RPB rules of practice, page 15.
Attachment 1.
Attachment LFE 23, attachment 1, yep, it's the same document, page 15. There's a paragraph F on that page, do you see it?
Not quite yet.
Yep.
Yes. Yeah.
Okay, it says that the presiding member or hearing officer at the conclusion of the hearing regarding a rate application will establish a schedule for the filing of briefs unless the applicant, Office of Consumer Affairs, and any parties having intervened waive their respective rights to prepare and file a brief. Do you see that?
Yes.
How often has this been waived?
Hasn't been waived to my knowledge.
So in every rate application, to your knowledge, to date, since you've been at the organization, I know you haven't been there the entire time, but there have been briefs filed with respect to every rate application.
I believe the practice and what that is, I'm just gonna share what happens is there's multiple documents and they're all read into the record.
Yes, but this is at the close of the hearing.
Correct.
And so briefs are read into the record?
I'm not at the, let me confer. For the decision, but at the end of the hearing, there's actually a read-in. It would include responses to interrogatories, what the interrogatories were, the presentation that was made, the application itself. So all the correspondence get read into the official record. This is prior to the final decision.
And you didn't list the brief. So again, my question is the brief read into the record as an item that's included at the end of the hearing? Typically, at least at Pura, the hearing closes and then briefs are filed. And so it's not typically in. And so what I'm trying to understand is the process at the RWA, how the briefs are done.
In the case, if there was an intervener, since I've been with RWA, there has not been an intervener in our rate applications.
Has the OCA ever filed a brief in a rate application?
The OCA always, and we provided these, will provide a memorandum prior to the hearing based on his review of the rate application. And he does usually testify also, and he's available to answer any questions.
After the close of the hearing, does the OCA provide a brief?
Yeah, his memorandum is his brief.
His memorandum that's filed before the hearing, correct?
Yeah, and his testimony at the hearing, yes.
Okay, thank you. Same document, Article 2, applications. Hold on one second. Which starts on page 10. And there's section 24, which starts on page 11. Do you see that, which is called form?
Yes.
And my understanding is that all applications submitted to the RPB are required to include the information from section 24, no matter what they're for. Is that correct?
Yeah, there are certain things that are required regardless, and then there's certain things that are specific to the type of application.
Okay, and so the things that are required regardless are set forth in section 24?
Can be confirmed. Yes.
Okay, and because this transaction is an acquisition, the application must also include the information from section 33-A. Is that correct?
I believe so, but I'm trying.
Which is on page 16 of the document.
Yes.
Section 40, same document, page 22, section 40. This is related to complaints, consumer complaints, correct?
Correct.
And it indicates that the rules govern the disposition of complaints made to the OCA or the Consumer Affairs Committee, in that case, the Consumer Affairs Committee of the RPB, correct?
Correct.
And after all internal authority management steps regarding such complaints, What are the internal authority management steps regarding those complaints?
There was actually an interrogatory, I believe, and I'll have the number right in front of me, where we talked about the escalation process, but I think similar to other utilities, if a customer calls in and, first it's with a customer service rep, and then it would go to a supervisor. Then at RWA, we do have a position called customer experience manager. It would go to that individual. And then it would, if it's still not resolved, it would go to management, a higher level of management. And of course, at any time, the customer could reach out to the OCA directly. But if it can't be resolved internally, it goes to the OCA for a resolution. And I will say sometimes, depending on the situation, management may actually confer with OCA just to get input, even if if whatever the complaint was, if it's some nuance that perhaps we haven't experienced before, we might reach out to the OCA to get input.
So that page 22 indicates that complaints made to the OCA go first to the internal authority management steps.
If it goes to the OCA first and it hasn't gone to management yet, yes, the OCA will refer the complaint to management to see if management can actually resolve it. That doesn't usually happen, but it could happen because the OCA is not the first step in the escalation process.
For Aquarion, if someone complains to the Office of Consumer Counsel, does the Consumer Counsel say, you're not supposed to be here yet, go to the company first? I know they'll reach out to the company, but do they send the customer back to the company?
There is a process, yes. We have a consumer advocate employee position that will usually work to rectify any concerns that are raised.
Okay, but my question was, if the Office of Consumer Counsel, at the State Office of Consumer Counsel, receives a complaint from a consumer, do they say to the consumer, just go talk to Aquarion, and if they don't satisfy you, come back?
So the process is supposed to be a customer comes to the company first. If they're not satisfied with the company's response, then they go to file with OCC or PURA. So if OCC receives a complaint, they should report it back to us so we can work with that customer. If that makes some sense.
So it would be the same in our case. If it goes to the OCA without going to management, the OCA would refer to us.
Right. I understand the RWA process. I'm trying to understand the Aquarion process. So the Aquarion process, if the OCC receives a complaint, do they just tell the customer, you should go to the company and don't come here until you're not happy with the resolution? Or does the OCC try to actually, mediate's not the right word, not in the legal sense of mediate, but in the sense of trying to collaborate between the customer and the company?
So
If I can just interject just for 1 second, not objecting to the question, but for clarity, and the company can certainly answer this question, but this does seem to be a question for the OCC in terms of how they would handle this type of a process. To the extent the company knows or is involved in that process, of course, they can answer to that.
And I would just say, depending on the particular situation, it doesn't mean that the OCA is totally out of it, but he's giving management an opportunity to resolve.
Thank you. Back to the Aquarion process.
can you repeat the question again?
Yes.
We have
So
a minute.
when you receive, let me ask it this way. Does OCC ever reach out to you about a consumer complaint where the consumer has not already come to Eversource?
Or Aquarion.
Excuse me, Aquarion, apologies.
We do get customer complaints that come from various agencies without coming to us first.
Including the Office of Consumer Counsel?
I can't speak to because I've never received one from the Office of Consumer Counsel.
The Consumer Affairs Division of the Public Utilities Regulatory Authority?
Yes.
Thank you. And when a complaint comes from PURA's Consumer Affairs Group, does PURA stay involved in the process in that they expect Eversource to copy them or respond directly to them about the complaint?
Yeah, so our consumer advocate will get involved, and the department that person's complaint is associated with gets involved. We communicate with the customer, and then we'll communicate back to Pura on the outcome and give them status. And if there's a longer resolution, we do an interim response that we're still working on it with the customer.
The same provision, section 40, refers to final action by an authority review officer. Who's the authority review officer?
The VP that customer care reports to.
Late file 23, attachment 2, is the authority board bylaws, correct?
Yes, although I'm still having difficulty opening it.
Late file 23, attachment 2.
It's got some organizational items and then it's got the bylaws, yes.
Okay. And those bylaws would control the activity of the RWA board when it's acting on behalf of the AWA? Is that correct?
That's correct.
And do you expect the AWA to adopt bylaws with similar provisions?
Yes.
Thank you. Same late file, page 5, section 1.9. So again, late file 23, attachment 2. This indicates that 3 members constitute a quorum for the RWA board. Is that correct?
Given that it's 5 members, if the board is expanding, I believe our enabling legislation clarifies that with the expanded board, the quorum would increase, but this is based on the current 5-member.
Section 38 of the 2024 Public Act indicates that as of January 1st, 2025, 4 members would constitute a quorum, doesn't it?
That's actually under the scenario where the board goes to 7. However, the enabling legislation, I believe it's probably, I don't have this section, I don't have the enabling legislation right in front of me, but there's language in there about if this acquisition happens and the board goes to 11.
And so are you willing to accept, subject to check, that the enabling legislation doesn't say that the 4 members constitute quorum after January 1st, 2025, only if you went to a 7-person board?
Correct.
Thank you. Same document, late file 23, attachment 2, page 7, section 2.1. This talks about the officers of the RWA, correct? Identifies the officers?
Not quite there.
Oh, okay.
What's the section?
2.1, it's on page 7.
Bonds and notes.
Those titles are titles of the board.
The page 8, bonds and notes?
No, page 7, section 2.1, designation and election. Do you see that? This identifies the officers of the authority board, correct?
Correct.
And it indicates that the chairperson and the vice chairperson are required to be members of the authority.
That's the authority board in this case.
Okay. But the secretary and treasurer do not need to be members of the authority board. Is that correct?
They currently are, however. The secretary and treasurer is a board member.
Currently, but they do not necessarily have to be under the bylaws, correct?
According to the bylaws, it would appear so. However, that hasn't been the case since I've been with RWA.
Same attachment, so late file 23, attachment 2, page 9, section 4.1. This indicates that a 2/3 vote of the entire authority would be sufficient to override the 50,000 public bid, 50,000 public bid requirement for contracts over 50,000. That's one of the ways to override that requirement, correct?
Correct.
Okay. And my question is, currently, the entire authority refers to the 5-member RWA Authority Board, correct?
I believe so. Sometimes it is confusing, yes, but yes.
Okay, and so since there's 5 members, would that mean that you need 3 votes or 4 votes to not have to engage in the $50,000 public bid requirement for contracts of a value of 50,000? It's like 3.3 something percent, so that's why I'm asking.
It should be for,
So 4, okay. And then it indicates that they can, that 2/3 vote can be used to override the requirement when it will be in the best interest of the authority. And again, the authority means the authority board, correct?
I would say the authority in that case is referring to the entity RWA. There's a process that we go through when we need an exemption, or we're requesting an exemption from public bidding. And there's material that's put together that goes to the authority board.
Understood. What I'm trying to get at is what would qualify as something being in the best interest of the authority?
An example may be that if there is a certain manufacturer that's used for like a key piece of equipment, and we're using it, let's say today in, let's say, every water treatment plant, but there is another vendor, but there's cost efficiencies of using the same manufacturer, that would be an example. Another example is,
Can we just stop at
sometimes
that
we-
example for a second, and then you can give me the next one in a minute, but I have a follow-up on that actual particular example, if you don't mind. Wouldn't that example fall under the exception for, that's already in here?
sole source, it wouldn't be a sole source if it's not a sole source.
Okay, go ahead then, please. Please continue with the next
My other
example.
My other example is sometimes there is an advantage to being able to negotiate as opposed to publicly bid. You might actually be more successful. So if we made that case, that could actually be potentially another exemption, again, if the case demonstrated that was in the best interest of the authority.
If you don't run a competitive bid, how do you know the negotiation is actually the better solution?
Sometimes we do based on input because in a public bid, because it is public, a certain vendor may not want to disclose that publicly.
Isn't there an exemption under FOIA that would protect the bid?
I don't believe so I'm not the attorney, but if it was a public bid, you have to go through a public process.
The process that, let me back up for a second. The process that you went through to submit a bid here, I know it's not this is the
Different.
bylaws we're talking about, you being RWA purchasing something. Now I'm talking about RWA technically, I guess, purchasing something, but I know it's not this particular provision that applies. That's not what I'm trying to get at. My question is, when the RWA is a public entity, correct?
Correct.
And its records are generally public, correct? But the bid, the amounts that the authority was considering bidding, including the maximum amount that we talked about at the last hearing, that information was done subject to protective order, correct?
It was a competitive situation.
And so a competitive bid.
It was a competitive bid.
Okay, thank you. Same attachment, page, section 4.4, which is on page 10. So this provision addresses conflicts, essentially, potential conflicts of interest, correct? Okay. And subsection A indicates that if a member or employee of the authority or subsidiary or affiliated business entity is financially interested in or has any personal beneficial interest directly or indirectly in a proposed contract or other items. How do you define a direct financial or personal beneficial interest?
I would think just an example, hypothetical example would be, let's say the member owns the vendor that's going to be providing the, significant service on, let's say, a capital project. That could be a conflict, would be an example.
So that would be an example of a direct financial or personal beneficial interest.
Correct.
Okay. What is an indirect financial or personal beneficial interest?
Typically, an indirect would be, let's say there is, we use consulting engineering firms or contractors. And typically when we go to conferences, if they actually sponsor a breakfast or something, could be an indirect one. It isn't exactly, I would say, a direct one where they benefit out of it, but it could be a sponsorship to a golf tournament or something. So we are very particular in avoiding any of those things. So both direct and indirect.
Where is the definitions or the examples of the direct and indirect financial and personal beneficial interest memorialized?
There is another document that is used. It's something that we added a few years ago on the RPB side, where it provides some additional language to better explain what a conflict is. And I think we've, through the feedback over the hearings, we probably will make more robust, given some of the concerns that have come up to further define a conflict of interest for the expanded board.
Same attachment, I think actually the same page number, subsection B of section 4.4. This indicates that no member, that means a board member, correct, of the authority?
Correct.
Or employee, or subsidiary and others, shall accept or receive directly or indirectly, for the record, this is not a complete quote, I'm summarizing, from any corporation to which any contract or purchase order may be awarded or anything of value in excess can't take by gift, rebate, otherwise, any money or anything in value of excess of $10, correct?
Very restrictive, yes.
Okay. When the AWA is constituted, for lack of a better word, my understanding is that the CEO from both for the same CEO will be the CEO of RWA and the CEO of the AWA, correct?
Under the legislation, yes.
Okay. And will that person receive compensation from both of those entities?
That's what's anticipated.
Okay.
Maybe a cost allocation is what's anticipated. Be a cost allocation. So if the person is like with RWA, we would do a cost allocation. We've talked about that. And that's also another one of the inputs that we will be preparing a cost allocation manual.
Okay, and so the expanded board will be the same board for the RWA and the AWA, correct?
Same people, technically two boards.
Okay. And will they be separately compensated by the RWA and the AWA?
It would be expected to be that way, yes.
Okay. And who will establish the amount of that compensation? Will it be the current RWA RPB for the RWA Board of Directors?
We would expect it, so for the RWA board, it would actually be the RWA RPB. We'd anticipate for the AWA authority, it would be AWA. However, I think my personal opinion would be want the compensation, I think, to be comparable. I'll use that word.
Same document, section 4.5A. Which is on page 11, starts on page 11. And subsections 2 and 3 refer to, quote, unjustifiable risk of serious injury to the authority, end quote. What constitutes unjustifiable risk?
Which section are you?
4.5A, subsections 2 and 3.
You're on page 12.
Not sure, we're not following where you are.
We are on 4.5.
4.5, starting on page 11, there's A1 definitions, then there's 2 limitation of liability. Okay. And then on the next page, actually 2 pages down on page 14, there's 3 titled indemnification. So 2 and 3 contain the language, quote, unjustifiable risk of serious injury to the authority, end quote. What constitutes unjustifiable risk?
I want to read the content. I think this is a legal definition.
Okay. Where would that definition be found? Is it memorialized somewhere in a different document?
I don't believe so.
Okay. And what constitutes serious injury? Would that also be a legal definition?
Believe so.
And do you know if that's memorialized in another document somewhere?
I don't believe so as it relates to the bylaws.
Okay.
I don't believe we've had these situations.
Going now to late file exhibit 24, attachment 1. This is the public hearing transcripts from the RWA RPB related to the application to submit the bid, correct?
Correct.
Okay, and on page 10, there's a testimony that much of the RWA Board of Directors or the RWA Board oversight is carried out through 6 committees, and then the committees are listed there. My question is, are all members of those committees members of the Authority Board?
Yes.
Okay. And how are the members of each committee selected? Are they appointed by the board chair?
The chair is appointed by the board chair. And then, like I said, all the members participate in each of the committees.
Oh, so all of the members are appointed to all of the committees essentially?
Yeah, yes.
Okay. And I'm going to move on to late file exhibit 24, attachment 3 on page 22. So this is the August 27, 2024, 7 p.m. hearing transcript. On page 22, the president of local USW 12160 is testifying, correct?
Correct.
And that is the union at the RWA, correct?
Correct.
And she testifies that they've been working without a contract for nearly 18 months, correct?
That's her testimony, yes.
And she also testifies that they were, I think the word she used is forced into arbitration. Is that correct?
Whatever it says in the transcript.
Okay.
Yeah.
Do they have a contract now?
Yes.
Okay, when was that contract entered into?
The contract was finalized in January through the end, which was the end of interest arbitration.
So January of 25.
Yeah, I believe so, subject to check.
Okay. And when does it next expire?
It actually is expiring in April of 2026, and we will be beginning negotiations relatively soon.
Okay. And Aquarion has an existing collective bargaining agreement as well, correct?
Correct.
And that's being, I believe, under the purchase and sale agreement, being assumed by the AWA, correct?
Correct.
When does the current union contract between Aquarion and the union expire?
Just give us a second. Can we do that as a read-in? I just don't know that. And is that okay?
That's acceptable to me. I don't know how much of a break there's going to be next, but that works for me.
Need to make sure we get it right. Thank you.
Sure, I can mark that as, I'll do numbers for the clarity of the record, so it'll be read in 1.
Thank you. Same attachment at page 29. This is Senator Fazio testifying, correct?
Believe so, yes, we're
Okay.
getting there.
Let me know when you're there.
Yes.
Okay, so this is part of Senator Fazio's testimony, correct?
Correct.
And he raises concerns that the hearings are held in New Haven and not Fairfield County. Is that correct?
He does, although they were hybrid.
Understood. When there's a rate application in front of the RWA, where does the RWA RPB hold its hearings?
The rate applications are held in New Haven.
Okay. And when the AWA RPB holds hearings on rate applications, where do you anticipate those will be held? Bridgeport?
I would expect so.
Thank you.
And
Late
they're
file.
and they're hybrid. I mean, currently RWA's RPB meetings are hybrid.
Okay. Late file 25, attachment 1. I believe these questions are actually going to be, I think both companies actually will be answering. So whoever's best suited. Late file exhibit 25, attachment 1 at page 1 indicates that service company in this context is the Eversource service company, correct? Agrees to furnish to associate company, and in this case, associate company are the various Aquarion entities, correct? Can you just speak into the microphone? Sorry.
Yes.
Thank you. And it says, to the extent requested by those Aquarion companies, accounting, corporate, finance, internal audit, legal, and treasury services, correct?
Yes.
Will RWA provide these services to the AWA?
So at this point, our understanding based on due diligence is there's minimal support actually coming from Eversource. One of those examples is Treasury. And I think for Treasury, it would not necessarily be RWA. It may be, and this is subject to further preparation for the closing. There may be an opportunity to use existing Aquarion finance staff as an example to perform that function. However, if that was impossible, RWA could do it, at least initially, because we do have a treasury aspect to what we do.
But it sounds like the long-term plan is actually not to have RWA provide those services. Is that correct?
For treasury, that would be correct.
Does RWA plan to provide accounting services to the AWA?
At this point, we believe that the staff at Aquarion would be sufficient. We do expect, though, as we've talked about, the conversion to governmental accounting and such is going to take some time. So there's definitely going to be support that's going to be needed, but it's not anticipated that RWA is going to perform the accounting services.
Okay. Same document, same page, indicates that officers and other employees of the service company will, on request of associate company, serve without charge, other than as provided in the document, as officers or representatives of associate company. Will the officers and employees that are shared by RWA and AWA be paid by both RWA and AWA?
Again, we're expecting that any shared resource would be under a cost allocation.
So yes, through a cost allocation.
It would be anticipated, yes, assuming that they were really providing meaningful, support, not an occasional telephone call or something.
Well, but the CEO is the CEO of both entities, correct?
Correct, according to the enabling legislation.
Okay, and so the CEO won't be just answering a telephone call from time to time, I hope, correct?
Correct.
Okay, so that there will be, AWA will pay for the CEO's salary and the RWA will pay for the CEO's salary either through a cost sharing or some other mechanism, correct?
Correct.
Thank you. Same document, late file 25, attachment 1 at page 2. It indicates that the amount of the compensation to be paid is subject to review and determination by a variety of entities, including the Connecticut Public Utilities Regulatory Authority. Will the amount of compensation paid for share resources be subject to AWA RPB review and approval, or just authority, or just the AWA board's approval?
I wouldn't expect the board to get involved in a cost allocation, definitely not below the officer level. As we talked about, we'd expect between the CEO, the CFO, and the 2 presidents, we could work out what a cost allocation would be. And as I mentioned earlier, we are planning on developing a cost allocation manual. We just have not gotten to that yet.
Will the cost allocation manual need to be approved by the authority, the AWA board?
There may be some review of it just to apprise them, but we're expecting, again, this should be something that could be worked out between the group that I just mentioned. I think we're all familiar with different cost allocation methodologies.
So, no.
Not anticipated that it would need formal approval.
Okay. And would it need approval of the AWA board? I think I asked about the RPB before, now I'm asking about the board.
Not anticipated that it would require formal approval.
Thank you. Same document at page 3. This requires that all employees keep time records. Will the AWA and RWA shared employees be keeping time records with respect to their work on behalf of the entities?
We would expect so. Currently, RWA employees do time reporting.
Will the members of the expanded board be keeping time records that permit identification of the hours or percentage of time worked for the 2 entities?
And again, maybe more of a personal opinion, we're not expecting that the authority boards will be cost allocated. We're expecting that they'll have a predetermined compensation amount that would be, and when they're acting as the AWA would pay when they're acting as RWA, but we're not expecting that they'll be subject to time reporting.
Okay. And the OCA, it's going to be the same OCA for the RWA and the AWA, correct?
According to the legislation as it exists today, yes.
And will there be a cost allocation for the OCA costs?
Yes.
And will the OCA be required to keep time records?
Subject to further discussion and evaluation, if that makes the most sense, or if it should be just subject to an agreed to cost allocation.
Okay. Late file exhibit 27. This is the list of qualifications for the RPB, correct?
No, this is qualifications for the authority board, and this is, I believe we mentioned this in the response. So this is from a more recent search for an authority board member. So the nominating committee, which is an RPB committee, determines what the requirements are. And so this is a representative example.
And do you anticipate that and those are the qualifications for the RWA board currently, correct?
Correct.
And do you anticipate those same qualifications will be used to determine the members of the expanded board?
I would expect so.
Thank you. Late file 41 and late file 42. These provide similar information, one for the RWA and one for the Aquarion data. So 42 is the RWA data, correct?
We're in 41, well, 41 is Aquarion, so I assume so.
Okay. Late file 42 includes a note that says cost per mile is affected by such factors as project location, site conditions, material costs, and cost of labor. That same note does not appear in late file 41, which is the Aquarion data. However, is that also true for Aquarion?
Yeah, our cost per foot is significantly impacted on which community we're doing work in.
Okay, so it is impacted by project location, as you've just said, correct?
Correct.
Site conditions,
Correct.
material costs,
Correct.
and cost of labor.
Correct.
Thank you. Late file 56. This is the July application to the RPB for this transaction, correct? The public portion of the July application to the RPB for this transaction, correct?
Correct.
Okay, and this is just the public portion of the application, correct? Okay, was the RPB provided the entire set of materials, both confidential and public?
Absolutely, under a protective order.
And does the RPB generally have access to all of the confidential information that the RWA board is also privy to?
Yes, there's a form that they fill out that they understand is protective, and we go through the process, but yes.
And how about the OCA? Does the OCA also typically have full access to all of that same information? Okay. At page 1, there is a reference to confidential exhibit A. Without giving the confidential information, can you tell us generally what was in exhibit, like a very general description of what was in exhibit A?
Just let me read the reference and I'll tell you. There was some additional detail about what was envisioned as part of the acquisition.
And when you say envision, do you mean financially or non-financial or both?
I believe, and if you give me a minute, we could probably pull the confidential, but I believe A was more detail about like what entities we were envisioning, and at the time that was not public.
Okay. Is that information's public now, though, correct?
It is public now.
But the confidential exhibit wasn't provided here in this proceeding?
the confidential portion, no, the confidential portion was provided under OCC 2 under protective motion. It includes multiple things that we definitely still want to keep confidential.
Okay, so, but the entire exhibit was redacted. It wasn't that just portions of that exhibit were redacted, correct?
Correct, because it was largely highly confidential.
Okay. So in addition to the entity names, was there also financial information in that material?
I don't believe A was, but B and other exhibits definitely had financial information.
Okay, and so I was just going to ask about Exhibit B, so that was financial information.
I believe so. Again, I don't have all the exhibits, but there were multiple exhibits that were provided confidentially.
And I was just about to ask, were there any other confidential materials provided to the RPB besides confidential Exhibit A and confidential Exhibit B?
Any exhibit that was mentioned here. And I know in the presentation that we did, that was also provided under OCC 2 for the actual public hearing. There was presentations that were done in executive session that include financials, market information, and that type of information that was pertinent to the decision.
Okay, and this application was submitted before the public hearings that were held in August, correct?
Correct.
Thank you. Late file 59. So this was filed as a confidential document, correct?
Correct.
And it was filed fully redacted. None of the information was in the public record. Is that correct?
That's correct.
Okay.
Late file exhibit 59, which I think was filed by Aquarion. Is that correct?
It's the PSA schedules.
Yeah, so let's let Aquarion answer those questions.
So the PSA schedules.
Yep.
So I'm gonna, based on Attorney Canavan's remarks, I just want to ask the questions again with the responses from the Eversource Aquarion team. The late file 59 was filed fully redacted, correct?
Correct.
So no information in that, those schedules, even like the word none of it is public, correct?
Correct.
Okay. I'd like to refer you to Exhibit AWA AQ3, which is the purchase and sale agreement. Let me know when you have it up.
Yep.
On page 16 of the PDF, the page numbering wasn't clear, so I'm going to go by what number it is of the PDF. So page 16 of the PDF. That refers to permitted liens. Do you see that?
Yes.
And that indicates that the lien securing obligations of the company or the Aquarion subsidiaries are set forth on section 1.1A of the seller disclosure schedule. Is that correct?
Yes.
Are those liens filed in the public records of the towns in which they are, the properties are located?
I don't know the answer to that.
Okay. Going to page 27 of the PDF. There's a reference to the authorized capital stock of the company and the number of issued and outstanding company shares, and that's set forth in section 3.2A of the seller disclosure schedule. Is that correct?
That's what it says, yes.
Is that information publicly available from the SEC?
The subsidiary entities are not public entities, and neither is Aquarion. The Eversource share information is in the SEC documents. I'd have to check. I don't know for sure.
Okay. And for purposes of this, the company is defined as Eversource. Is that correct?
I believe so.
Thank you. At page 28 of the PDF, there's a reference to the seller financial statements.
Sorry, I just want to, the company in this case is Aquarion.
Okay. So Aquarion's information is not publicly available. Capital stock and the number of issued and outstanding company shares?
I'm not sure if it's in the SEC document that Eversource files annually. It may be publicly available through Aquarion financial statements that are filed with regulators. I just don't have those in front of me at the moment.
Okay. And actually, you're getting to my next question, which is at page 28 of the PDF, there's a reference to seller financial statements. The Eversource financial statements annual reports are publicly available. Is that correct?
Yes.
And the Aquarion annual reports are publicly available at the Public Utilities Regulatory Authority. Is that correct?
I believe that's correct.
Okay, thank you. I mean, I'll just stop there. I could go through about 15 more of these, but I guess what I'm getting at is that much of the information is publicly available information for which they have requested a protective order. And therefore, I ask that the authority reconsider its ruling, providing protective treatment to the entirety of those schedules and require the company to redact the truly non-public confidential information and provide that to the parties in this proceeding.
Thank you, Attorney Miranda. And just so I am clear for the record, the request for reconsideration is with respect to late file exhibit.
Right now it's 59, but I also have it for 61, but I haven't gotten there yet.
Understood. Would the company like to be heard?
Thank you. So I think the issue with respect to the seller's disclosures is that the disclosures themselves need to be taken as a whole. So we identified in the motion and in the affidavit that's attached to the motion that the seller's disclosures as a whole, they're commercially negotiated terms in terms of what goes into those seller's disclosures and then the information provided. They're deemed non-public information as part of that arm's length negotiation process. And the specific disclosures in this case are specific to this particular transaction and the negotiations in this transaction. So what that means is that if they're publicly disclosed as a whole, and if this transaction isn't approved and might need to go out to rebidding or a different negotiation process, the bargaining position from the seller in terms of the specific information that's in the disclosures is now publicly available and can harm their business interests in that next negotiation of the transaction. So the information in the disclosures need to be read and viewed and interpreted as a whole instead of each individual word or line or item in its own little silo. And I'll give you some more specific examples in terms of why that's the case. The purchase and sale agreement itself includes in its definition section a definition for for company material adverse effect. And it discusses that a company material adverse effect, if you scroll down to letter I, it specifically references any matter disclosed in the seller disclosure schedule solely to the extent described therein. And if you look at what a company material adverse effect is, it's defined right in that opening paragraph or right in the opening sentence as something that would reasonably be expected to present. Excuse me, I need to refer to the document and not my notes, which I can't read my handwriting. Something that would reasonably be expected to prevent, materially delay, or materially impede the performance by seller of its obligations under this agreement, or the consummation by seller of the transactions, or is or would reasonably be expected to be materially adverse to the business assets, financial condition, or results of operations of the company and the AC subsidiaries taken as a whole. And I think the key language is taken as a whole when you're reviewing the seller's disclosures and the information that's included therein. And that's consistent with the argument that if they were produced publicly, they would materially harm the company if this were to reopen negotiations or the bidding process. And I think the last thing I want to point out is the disclosure schedules themselves directly in their terms refer to the documents as the confidential seller's disclosures. So the company has taken steps to proactively protect those documents. They're not produced as a whole, as part of the negotiation process. They're not produced anywhere else in that manner with everything grouped in and included. And again, the company has taken steps to protect that as a whole. So therefore, in total, it's confidential, even though in its own silo, if you were to piece together certain things, I think that's where that's why it needs to be taken as a whole, because you need to consider what the company put into its negotiation process and why that's part of this particular transaction.
May I respond?
Attorney Miranda.
The PSA actually tells you exactly what's in the schedules. It just doesn't give you the material. So it says it is the financial statements, it is the permitted liens, et cetera. So everyone in the world publicly already knows what's in them. In addition, my understanding is that there's a confidentiality agreement that the RWA signed with the company, and there is a confidentiality provision in the PSA that is applicable to the seller, which would be in this case, the Eversource and Aquarion entities. And it indicates that the obligations of seller for confidentiality shall not apply to information which is or becomes generally known by the public. So we already have established that at least 6 things are readily known to the public. And so that to me means that it's not subject to the confidentiality provisions of the agreement either. So I understand the point that counsel has made, but I disagree that the information isn't already essentially out in the world.
And if I may respond to that, I think the testimony was they weren't sure in terms of what was or wasn't out in the public. I don't think that has been established or confirmed by the testimony today. What we do know, though, is that as it's presented in the seller's disclosures in its entirety is not a public document and hasn't been released publicly in that manner.
I don't believe the testimony was, I don't know for everything. In fact, for the financial statements, they admitted that all of the financial statements for Eversource and Aquarion are available publicly.
Okay. All right. Let me do this. Attorney Miranda, do you have other questions not pertaining to late file exhibit 59 or 61 remaining? It's just these questions.
Yes, and I have questions about 61 in a minute, but I haven't gotten to those yet. No, this has just been 59.
Okay. Are the questions pertaining to 61 of the same nature?
Yes.
Okay. Let's do this. I'm going to allow you to finish the questions for late file exhibit 61 that you have. And then we're going to take it under advisement and take a lunch break. And we'll resume after that. I need to discuss with my colleagues.
Okay.
So Attorney Miranda, if you want to conclude your questioning for
Thank you.
the time being. please.
And if I may, just one more thing, I apologize for interrupting. 61 is a bit different because 61 goes towards AWA's financial information and not the seller's financial information or not the seller's other negotiated terms that are in those seller's disclosures. So there is a bit of a distinction with respect to 61.
Okay, I thought 61 provide the debt financing letters as referenced in section 5.4 of the PSA, but you're saying because the debt financing letters pertain to AWA, it's different?
Yes, correct.
Okay, so
it has elements of the same argument, but it is a slightly different argument in terms of the specific reasons for confidentiality. And in the motion itself, we cite a very lengthy paragraph of precedent in terms of why it should be held confidential.
okay, does the company wish to stipulate, or I'm sorry, Attorney Canavan?
Yes. No, these debt financing agreements are, as we think, are highly confidential. They're issued by financial institutions. And I think the testimony would be from the witnesses that lays out the financial terms of this transaction. And we do not believe that these should be made available or that your pector order that you granted should be reconsidered.
Okay, so I think the question I was going to ask is no. So AWA, or excuse me, Aquarion is not prepared to stipulate I think we just need to go through the questions. Okay, Attorney Miranda, please.
Thank you. And I do take Attorney Canavan's point that certain terms are confidential. My dispute is not with the overall confidentiality of pieces of the material. It is with respect to the fact that these two documents have been completely redacted from the record and there's no access publicly to any of the information. So with respect to late file Exhibit 61, these are the debt financing letters for AWA, correct? I'm sorry, your microphone.
Just for the bridge.
Okay. And typically these debt financing letters have things like the name of the borrower and the name of the lender, correct?
I assume so.
Have you seen the documents?
I've seen these documents, but I haven't seen other bridge commitment documents.
Do these documents contain the name of the borrower and the lender?
Correct. Yes.
And that information has been disclosed in the course of this proceeding, is that correct? The borrower would be the AWA?
The borrower, yes. We may or may not have disclosed who the lead is and who the minority is relative to the bridge. I don't recall.
Do the debt financing agreements contain certain conditions precedent that must be satisfied before the loan will be finalized and the funds are dispersed?
I believe so. I would need to check.
Okay.
I mean, these are still confidential documents, right? This is not an executive session. The questions regarding the documents at a high level to establish what they are, correct?
That's correct. That's all I'm asking. I'm not going to ask what the actual names of anything is, et cetera. I'm just trying to understand generally what's in the documents. I'm actually not going to ask for reconsideration on 61. I'm just going to limit it to late file Exhibit 59.
Okay, thank you. So let me just ask a couple more clarifying questions about the request for reconsideration on late file Exhibit 59 before we take our lunch break here. Attorney Miranda, I'm guessing you're not going to be able to answer this question, but I'm going to ask it anyway. Do you know whether you wish to ask questions about, so if PURA were to grant reconsideration, I'm gathering because you have not had access to the documents that you can't tell me whether you would have questions on the substance or not, or are you just seeking to have them publicly available so that you can cite to them in a brief?
Well, I understand that this is the last hearing, so I don't think I'm going to get to ask questions about them. I'm going to have to take them on their face value to the extent they are disclosed, take them on face value for purposes of briefing and other pieces. I would love to have asked questions about them, but unfortunately, just given the very compressed time frame we were operating in, I did not have time to do so, to try to deal with this beforehand, so to speak.
Yeah. Okay. All right. So let's take our lunch break until 1:15. I apologize. I have one more question. Does either Attorney Miranda, on behalf of her clients or the company, and I think in this instance, the company is the Eversource folks, are either of you asking for an opportunity to make your arguments in writing, or are you asking for the reconsideration to be taken under advisement and rolled on after lunch?
My preference would be to have it rolled on now, but if you would like a written motion and a written response, we can deal with it. The issue becomes that I would need we would need that to move pretty quickly because the briefs are due not too long from now, and I would need the material for the brief.
Understood.
And I think with respect to our response, I think we'd be prepared, subject to additional information that you would be looking for, but we would be prepared for a decision after lunch as well, with the caveat that there may be like layers of information that even if let's say hypothetically, the motion for reconsideration is granted, does that mean the entire document is public, or is there an opportunity to redact further? Because there are certain layers of where the confidential information lies.
Okay.
Yeah, and to be clear, that is my concern. It's not that I take them at face value, that some of this information is actually not available in the public and is competitively sensitive, and I'm not asking for that. I'm trying to, there are materials in there, though, that we have established are publicly available, and so I am looking for a requirement that they file it more, rather than just nobody can see any of it, to let's take a harder look at what actually is and is not confidential.
Okay. All right. I think I've got a handle on this. So let's take our lunch break. We'll reconvene at 1:15. Thank you.
Madam Chairman,
Yes.
when you're ready, we have just two administrative matters, one pertaining to the confidentiality issue and one on the read-in. We can take whichever one you'd prefer first.
Very good. So we'll go back on the record and I will accept the read-in first, please.
Thank you. Ms. Zabo or Mr. Lawrence, do you have a response to read-in one?
Yes, it's March 31st, 2026.
March 31st, 2026. I'm sorry, I didn't.
Correct, yes.
Okay, thank you.
Thank you.
Okay, and the second item?
And the administrative matter on the confidentiality issue is we've conferred at the break and we'll produce a redacted version early next week.
Oh, okay. Of late file exhibit 59.
Of late file exhibit 59.
Okay. Does that satisfy?
Yes, thank you.
Okay. All right. Thank you.
Thank you.
Then I think we're up to cross from authority staff. Please. Attorney Coker, please.
Good afternoon. I am Bureau Staff Attorney Josh Coker. To start, I have a couple of questions about LFEs 41 and 42. If you could get those open, please. Okay. So I noticed, reviewing the numbers on this, that in 2015, the cost per mile for main replacement is comparable between Aquarion and RWA, with Aquarion at 1.5 million per mile and RWA at 1.4. However, starting in 2016, Aquarion's cost per mile of main replacement is much higher than RWA. Why didn't costs increase so much after 2015?
I think the primary reason, excuse me, is the locations we have to work, Greenwich, Sanford, and the endeavor to actually get into and replace mains in very congested areas that have a lot of traffic. So you have a lot of utility work. So our cost per foot is highly impacted by primarily the location you're working for traffic, the traffic control requirements, the town or city requirements, and then the production of water main, which is impacted by other utilities in the road. The more utilities in the road, so if you're in the middle of Stamford, right, you're going to have gas, drainage, sewer, electric, and other things. So that's the primary reason prices drive up. More recently, we've seen material price increases really since COVID, which really drove up some things like that. And the other reason, again, we've been doing some projects I don't think the company would have endeavored in the past, given our investment levels, downtown New Canaan, downtown Greenwich, and those are very expensive projects because of their proximity.
So you mentioned COVID, but it looks like the prices started going up in 2016. So COVID couldn't have been a factor in it at that point.
So we did see increases in material issues in COVID. The prices didn't reflect it primarily because we had better production because there wasn't anybody on the road, right? So the traffic control, we did some work in downtown Mystic in front of the seaport, which you could never do normally because of the amount of traffic there. We would have paid probably twice as much, but since there was no one on the road, no one doing anything, we were able to actually do things like that.
So you're saying the increase?
We saw increases in materials and material issues, but we saw a decrease in, or an increase in production, so therefore a decrease in overall cost.
Okay, thank you. Torrington Water main replacement costs are much higher than either Aquarion or RWA, about 4.5 million per mile in 2023 and 3.8 in 2024. Why is it so much higher than the other two systems?
So we've been working on replacing a 24-inch asbestos concrete main with new 16-inch ductile, so just downsizing that. So that's on Route 4. So between working in Route 4 and addressing the larger mains and the associated connections, that cost is significantly higher for that reason.
Okay, thank you. Second, please. Please refer to LFEs 49 and 50. Just looking at the numbers here, it's a similar question. I've noticed that the prices for Aquarion are roughly $80 to $100 more per million gallons for water treatment, and I was wondering if there was a reason for that. For example, in 2020, Aquarion was $484, RWO was $396.
Just give us a second. Thank you.
Of course.
Obviously, without studying regionals, water authorities' numbers, we can't directly respond to that, but we do have many more groundwater systems as on top of our 10 surface water treatment facilities we have, which does drive up overall costs.
Just to add to Dan's, response, it could be the surface water quality as well. So Gaylord normally has much better quality in terms of surface water intake quality itself. So that kind of adds to the treatment that's required. So that could be one other reason amongst, other reasons which we'll have to dig into. But generally the surface water instead of well fields or something makes a difference. So when you compare averages, kind of, I would say, is misleading to an extent. Even going back to the other question on 42, it depends on the pipe too, whether it's a 6-inch or a 12-inch or an 18-inch. You're comparing dollars per mile. But again, it doesn't take into account the pipe trenches that's required and the material sizes as well as that. So just to add a little bit more context to it.
Okay, thank you. I appreciate that.
Sure.
Now, please open the response to LFE 26. Now, just to confirm, appointing a board member requires 51 of the 101 weighted votes in RPB, correct?
Can you just ask the question again?
Yes, of course. To confirm, appointing a board member to the joint board requires 51 of the 101 weighted votes in RPB, correct?
Correct.
So as you may recall from our conversation at the previous hearing, I used the example of John Smith, a hypothetical AWA appointee to the board. Because John is appointed by the AWA to an AWA board seat, he needs 51 of the 101 votes in the AWA RPB. The RWA's RPB has no say in his appointment, correct?
It's the same members, so in effect, the RPBs can remove a member because it's the same 11 people.
Right, I'm talking about appointment.
Oh, for appointment.
Yeah, appointment, yes. So for example, John Smith is appointed by AWA. AWA has 5 seats on the 11-person board. And John Smith is appointed by AWA to one of those 5 seats.
Correct.
He needs 51 of 101 votes in the AWA RPB, but RWA RPB has no say.
Correct.
Thank you. Now, let's say that John Smith is not an ethical board member and he takes various actions in official capacity as a member of the board that the RWA municipalities oppose and believe merit removal for cause. In our conversation a couple of weeks ago, you indicated that the RWA RPB on its own could remove John if it had 51 weighted votes in the RWA district. Is that an accurate characterization of your testimony?
Yes, if he was appointed by the RWA.
But what if he was appointed by the AWA? Could
Yes.
the RWA
Yeah,
remove
it works both ways.
Okay, so and then vice versa case where an RWA board member could be
Right.
removed by the AWA RPB.
Correct.
And would that require just the 51 votes from one of the RPBs, or does it need a majority of both RPBs?
The way our understanding of the enabling legislation, it would be of the RPB that appointed the board member.
So the RPB that appointed the board member gets to remove them, but
No, anyone could, I'm probably confusing it, anyone could remove with the majority of the votes because they're the same 11 members. And then on the appointment, if it's an RWA appointment, it would be like the RWA, RPB. If it's an AWA appointment, it would be AWA. I'm not sure I'm answering your question though.
it seems like I may be misunderstanding, but it sounds contradictory because if John Smith, the AWA appointee, is being removed, he could be removed by a vote of 51 AWA RPB members.
Correct.
Could he be removed by a vote of 51 votes in the RWA RPB if the AWA took no action?
Not for, but again, I think the nuance is that it's the same 11 people. So it would be a question, the AWA RPB could remove any of the 11 members and the RWA RPB could remove any of the 11 members because it's the same 11 people. It's 2 boards.
They could do that. They could do that even if nobody in the RPB that appointed that person voted for their removal, if they had a majority in the other RPB.
Theoretically.
Okay. So let's say that John Smith was removed and he was appointed by the AWA. He was removed by the RWA. The AWA didn't vote on it at all. So 51 votes in the RWA RPB removed John Smith. What would prevent AWA from immediately reappointing him?
In this hypothetical, I guess that could be the case. I don't think it would be, I'm not sure how it would go. I wouldn't envision there would be back and forth forever. I would think probably the 2 chairs, it's just my personal opinion. There would be some, conference between the 2 RPBs.
I mean, this is an area that we are still working on. I think this is one of the areas too that came up during the last 3 days of hearings. As I had mentioned in the morning, these are, I would say, some points that we are actually looking internally as well as talking to the boards to see how to kind of navigate these conflict of interest. And once we have some kind of a draft, I'm sure we will kind of, I would say, collaborate in a fashion with, the AG's office or OCC's office to make sure that these are kind of codified in a way where it is acceptable to both the RPBs.
But they are not currently codified anywhere.
Because it is still a work in progress.
So
Because
it's not in the statute.
Correct. Till last year, it was only one authority. So only after last year's special session, the theoretical, I would say, AWA is existing and RW has been there. So these are, I would say, feedbacks which we have taken, and we need to develop, I would say, those procedural areas. Yeah.
I think that would come under what was referred to earlier with, documenting a broader, like code of ethics, code of conduct that addresses some of the things that have come up.
So you just stated previously, this is not currently in the statute.
This is not currently in the statute.
The boards can remove a member is in the statute in each section. So it's in the RWA sections and the AWA section. But I think what you're talking about is the unique circumstance that may present itself given the makeup of the board, the authority board.
Right, so just to restate the situation, the appointment of the threshold for appointing someone to the board is already in the statute. That you need 51 of 101 votes.
Correct. The removal is also that any RPB member could, remove a authority member, that the RPB could remove an authority member is also in the statute.
Okay, so both removal and appointment are in the statute. Then if that's the case, how could guidance add further restrictions on this if they conflict with the statute that's already written?
I think how, like in your example, again, this is my personal opinion, but given there could be in the rules of practice or in the bylaws, there can be how, if there was actually a situation like you mentioned, like a mechanism to resolve it.
But there's currently no procedure, no bylaws for resolving the situation.
Not the particular one that you're mentioning.
Do you think that would require an amendment to the statute?
Not necessarily. It is my initial reaction.
What would be the timeline for guidance to resolve issues like this?
I think based on the feedback that we heard and given some of the concerns that have come up regarding, I guess what I'll call like conflict of interest generally, I think that's something that we need to work on rather soon.
But isn't it true that based on your testimony at the evidence you're hearing, that you were aware of these concerns during your meetings from municipal leaders well before this was even brought to the authority?
Not these kind of specific examples per se, like a removal of an RPB by one RPB and then reinstating the other, I would say, RPB, because the concerns that were raised mostly was on the board, the 11-member board, not particularly this example you cited.
Okay, let's change the topic a bit. Please turn to the response to LFE 36. So in this response, RWA describes 3 lawsuits, one for damage to RWA's real property and 2 suits to appeal tax assessments. So I have a few questions about these lawsuits. First, let's start with the lawsuit for property damage. Your response says, quote, RWA management made the decision to bring a legal action on behalf of the RWA to recover damages. Who specifically is the RWA management you were referring to?
In this case, I did.
You brought the suit?
Yeah.
Did you make that decision on your own?
No, I think I spoke to the council.
You spoke to the council?
Correct.
Did they have to approve your decision or ratify it in any way?
No, we generally discuss, I would say, these kind of cases and see what would be the appropriate way to approach these things. And there is a real estate manager who works under the same division. And he also looks at, I would say, the particular, I would say, incidents that happened. And then it's a decision by the management.
So purely by management. And by management, you mean the C-suite in general?
Correct. Yeah.
Okay. So the RPB and board don't weigh in an official capacity, you just consult with them?
Depends on, I would say, what the case is. Right? Depends on whether it is really required. It doesn't go to the RPB. In this particular case, it did not go to the RPB.
Why did it not go to the RPB?
This kind of case, it generally gets mostly managed by the management, and that's how I think the structure is. It's left to the management to make these executive decisions.
Why is it left to the management? Like, what's the basis for it? Is that in the bylaws?
I have to check whether it's prescribed in the bylaws, but Generally cases like the PFAS class actions and all that, we bring it to the authority boards. Typical, I would say, cases that whether it's going to be construction contracts or whether it's going to be these kind of land disputes gets handled by the management.
Can I just add, in this particular case, I mean, the dollar amount was relatively low.
If it was higher, would that have made a difference?
If it was significantly higher, it may have made a difference. I mean, this particular case was settled.
Correct.
May have made a difference. Why, what's the reason for the uncertainty?
I think it depends on the magnitude. It depends on what the case is about.
Is there a threshold at which board approval or RPB approval is necessary?
There's not a explicit threshold for RPB or authority approval, but it does, depend on the situation and the case. And if you're and in this case, right, we were the plaintiff in these cases.
So there's no specific threshold. Is that an accurate characterization?
Not at this point of time, as far as I recall, I can check, but at this point of time, there is no specific threshold per se.
So if the RWA was sued for $100 million, we don't need to specify why, but to say a large
We would definitely be in discussions with the board.
in discussion,
Thanks.
but would they have to approve the decision to sue, to not sue, or the legal?
Yeah, I think for a significant dollar magnitude, we would. I will just, share an example where there was a opportunity for a settlement related to, under our insurance, but a settlement. And because of the magnitude, yes, we discussed it with the board.
You discussed it. They didn't approve the decision,
They concurred with the decision.
but they didn't have to take a vote, a majority of the board, maybe making a motion.
Yeah, I don't recall, but actually in this particular situation, this goes back a few years, just to share some more detail. So we got a sort of a not to exceed amount, from the board, and they were available to reach out should the discussion go in a different direction.
Maybe this will make it a bit clear, this question. Is it your position that the executives of RWA can bind the RWA to litigation, either by suing or by making decisions to settle or the like, without direct oversight by the board or the RPB?
I mean, this is.
I think there's a difference between if you're a defendant and you're settling versus like these particular cases there where we're bringing suit. And just based on the nature of these examples, there was not a need, in our opinion, to bring it to the authority board for a vote.
What do you mean by in your opinion? So this was just a judgment call by the executives?
In these cases, the appropriate executive made the decisions to bring these cases forward in consulting with legal counsel.
So is it correct to say the answer to my question is yes, you do not need direct oversight from them to make decisions?
These are where we're the plaintiff. And like I said, in my other example of the settlement, because of the magnitude, we definitely conferred with them. And, the example about the PFAS and how we handled that, there was some, strategy as to, participating in the class or not participating in the class, and that warranted discussion with the authority. There were significant dollars that were involved. And so that was a discussion with the board.
Well, I understand, but you keep using the words concur and discussion. So this is, again, not a formal vote of the board.
So for the PFAS, I believe it was a formal vote as to how to proceed. In certain cases, it could be more of a discussion and information. If there's strong disagreement, management would definitely react to the board's opinion.
The board's opinion, but not the board's direction.
And what the board's, we would definitely take into consideration if we were discussing something with them before or even after, and they felt that management took the wrong action, we would reverse course.
But this is, again, still purely, there's no official rule, there's no bylaw. that requires their-
There's schedule of authorization, and there's a schedule of, like, in the case of like capital and acquisitions and, rate increases, that's all laid out. There's a schedule of authorization that management works under relative to who could commit to certain dollar amounts. It does not currently explicitly, talk about the threshold above which something would need to go to the board. In the example of the settlement that I mentioned, the magnitude was such that we definitely wanted to confer with the board before making a decision.
You mentioned a schedule of authorization. Is that on the record
No.
somewhere?
No.
Could the board block a lawsuit that they disagree with? And I don't mean that you would take into account that the board disagrees with the lawsuit. Let's say RWA has a valid claim. The executives believe that you should bring a lawsuit. The board disagrees and thinks it should not happen. If talking this out did not resolve it, could the board force the executives to not bring the lawsuit?
I would think so.
I would think so. I think we would confer with the board, and based on how the board feels, we'll certainly take action accordingly. Just to kind of highlight on the point, operational issues, when it is smaller, I would say lawsuits, typically it's left to the executive team to kind of decide on it. We do update and we do confer with them. But if the board does strongly feel, I think the executive leadership team, as well as the managers involved, would not proceed with it.
Out of respect for their opinion, not because they were ordered to under penalty of law or the organization of the RWA.
I think it's in the interest of the authority, regional water authority, so to speak. It's the organization's interest that is being kept at foremost. So I think it's not necessarily mandated in that fashion, but certainly I think, it is considering all, I would say, factors. And if the management authority board does decide that it is in the best interest of the authority not to proceed with it, the executive team would actually proceed accordingly in accordance with the management authority board.
Would the AWA follow the same procedure for litigation that the AWA follow the same procedure for litigation that the RWA currently follows?
I would say generally, however, you do bring up a point that, perhaps we should add to our schedule of authorization, clarity regarding these type of situations.
What would be the timeline for that type of clarity?
We would, in this case, we would confer with the board and develop something that, the board was comfortable with regarding the criteria.
The RWA is not a new organization, is it?
Excuse me?
The RWA is not a new organization. It's been around for a while, correct?
Correct. Since I've been with RWA, there hasn't been like a concern about what we're bringing to the board. I mean, we do have, whether they vote or not, we confer a lot with them, both the authority board as well as the RPBA, as well as the RPB committees also. This hasn't come up as a concern.
I would like as a read-in the docket number or other case identification number for the lawsuits that were mentioned in the response to LFE 36.
Sure.
Mark that as read into.
Given the timing and the expected time left in today's hearing, I wonder if a supplemental filing of 36 would be more appropriate for that information.
A supplemental, yes, thank you. Just to supplement that late file exhibit with the docket numbers.
Very well.
Thank you.
One moment, please. No further questions for from the authority.
Thank you. Attorney Doyle on behalf of DPH. Thank you. Attorney Ball. Thank you. Attorney Bogan. Thank you. Save the sound. Vice Chairman. I also do not have any questions. So would the companies, would the applicants like a few minutes to consider redirect?
I think we can head right into redirect. Based on the discussion this morning, we only have, I think, 1 or 2 questions.
Okay, please.
Thank you. So my question is for Mr. Normand. You've been asked a number of times about the last 10 years, how the company has filed one rate case. And in the next several years, the company anticipates filing repeated rate cases. Can you please, to clear up any confusion, can you just reconcile those 2 different statements that the company's made?
Yeah, I mean, I think a lot has changed in the industry and specific with Aquarion over those 2 periods. So if you look back on the last 10 years, the company was operating under a rate order that allowed an ROE of, I believe, 9.6 or 9.3. There were some favorable tax rules that came out that allowed for favorable cash flows to finance a lot of the capital investment. In the middle of that 10-year period, there was actually an acquisition where Eversource acquired Aquarion. So there were a number of reasons why the company didn't file during that 10-year period. I think if we fast forward to where we are today and looking forward, the industry is undergoing a big change. There's tons, billions of investments that need to happen, as Rochelle's been saying. A good chunk of which is compliance related around lead replacements and PFAS. And there's a number of major life cycle upgrades that need to be done in the next few years. We have to replace a water treatment facility. Mr. Lawrence has talked about some of the key things in the capital plan. So given where we came out of the 22 rate case with a lower ROE and the amount of capital we need to spend, the only way to continue to sustain the business and do the necessary investments is to file rate-based resets effectively on an annual or semi-annual basis. And so that's absolutely the plan going forward to the extent that this transaction doesn't happen. And that's what Eversource has built in to its projections. And it's really the only way that we can continue to generate enough cash flow to support the business. I think our ROE in 2024 was like the mid 5% on an authorized of 8. And so we just believe that the strategy needs to be going forward in order to sustain the capital investment and meet the water quality standards and meet the quality of service we owe our customers, is to get those rate-based resets and get our and accelerate some of the recovery of those investments. So I just think the prior 10 years and the next 10 years are very, very different, and that's important for folks to understand.
Thank you. No further questions.
Okay. Thank you. The witnesses are excused, and let me just cross-check our notes before we adjourn. I think I wrote down 2 supplements. I'm sorry. I wrote down 2 supplements. Does that?
Yes, I have. I'm sorry, Gilette. We have supplement 9 and supplement 36. Is that what your notes have?
Yes.
Perfect.
So if the company can have those filed before the close of record, and the first round of briefs are due on August 22nd. I'll pause and see if there are any administrative matters from any parties or interveners before we adjourn. Nope. All right. Thank you. We are adjourned.
You. Thank you.